Mr. Illingworth.
Thank you, sir. I thought I'd start the day by informing Your Honour that the live streaming is having an educational effect and also an effect of helping counsel to run their case. I got an email from a law student named James Lynn, who helpfully informed me that my reference to taking rights seriously was in fact a reference to a work by Ronald Dworkin, so I'm grateful to Mr. Lynn.
I think I mentioned it, didn't I?
Well, you may have mentioned it. You mentioned it, then I mentioned it. I think that's the... So...
well, that's good.
And we have a correction too, sir. We said in submissions that the Bennett and Horseferry Road Magistrates Court had been approved at Supreme Court level in one of the Dotcom cases. That was incorrect. It's actually the Wilson case where that occurred, but it has been approved at that level. Now, Your Honour, we now come to Part G of our submissions,
Yes.
which are the eligibility submissions. I need to make an important correction on page 1, paragraph 3A. We said we canvassed the following issues. A, whether the district court proceedings were tainted by procedural fairness. It's not quite right. So we could change that to procedural unfairness. And
I think I understood what you were talking about.
Indeed. We have set out some key documents on...
I mean, you might be saying that's actually a fair reflection of your position.
What's that, sir?
Oh, no, that's right.
Well, no, I don't say that. I say it's certainly the corrected version. Now, page 2, we set out some of the key documents, and obviously, sir, the superseding indictment is a key document.
Yes.
And it's a challenging document to digest.
Well, it's the starting point, isn't it?
It is the starting point. Now, we're going to be looking, in particular, in the first part of our in part of our submissions today at section 24.2c. Yes. Which says that the offence the court must be satisfied that the offence is an extradition offence. And there are some issues and difficulties with that which we will need to traverse in some detail. But we first deal with the background, starting on page 2. These are issues that have been well and truly covered, and I'm not going to read out those sections. We go to page 5, where we look at the eligibility hearing itself. And if I can start on page 6, Your Honour, at paragraph 18, where we identify the US case in relation to extradition offences. So the critical question is...
This was supplied in the correspondence leading up to the hearing, wasn't it?
The table?
The table we're looking at.
Yes. The contents were in the 25 March letter. Yes, sir.
Yes.
Not in that form, but certainly that was the...
It provided that information.
That information was provided. Now, Your Honour, in order to ascertain whether an offence is an extradition offence, we really need to just go back for a moment to the statute. I've got the wrong volume. So we're in the US Bundle of Authorities at tab 1.
Yes. So we start with section 4.
I'm sorry, sir?
You start with section 4.
Well, yes, we can do it that way, sir. I was going to go to...
You start there, but Callanan says you go from there to the treaty.
Yes, but the actual operative provision is section 24(2)(c).
Yes.
So that's where I was going to start, sir.
Right.
And it's important to go there for a reason which hopefully will become obvious. So subsection 2 of section 24 says the person is eligible for surrender in relation to an extradition offence for which surrender is sought if, and then we go down to C, the court is satisfied that the offence is an extradition offence in relation to the extradition country. Now, I don't want to be overly technical, but the offence must refer to the offence in the indictment. Otherwise that sentence doesn't make sense. What is the offence? The offence is an extradition offence in relation to the extradition country. Now, if we go to section 4 and look at what extradition offence would mean without a treaty, we then have a very easy syllogism. We've got the 1A provision, which is applicable to a person who's not yet been convicted but is accused, and 1A covers the situation where it's an extradition from New Zealand to another country. So that's simple. We then have subsection 2, and this in our submission is important. So the condition referred to in subsection 1A is that if the conduct of the person constituting the offence in relation to the extradition country or equivalent conduct had occurred within the jurisdiction of New Zealand at the relevant time, it would, if proved, have constituted an offence punishable under the law of New Zealand, etc. Now that is an elaboration of subsection 1A. That leads us to a conundrum, because in Cullinane, which is tab 9 of the US bundle, and that's MOAUT 093, if we can just follow the logic of Cullinane through, looking at paragraph 53 on page
Yes, I've got it.
13. Significantly for the instant case, the definition of extradition offence in section 4 is, quotes, subject to an extradition treaty. Furthermore, section 11 requires that the Extradition Act as a whole be construed so as to give effect to an applicable extradition treaty. While section 11 states that such a treaty cannot override certain core provisions of the Act, these core provisions are not relevant in the present case. And so all of that is perfectly unremarkable. But then going down to 55, as section 11 requires the Act to be construed to give effect to an applicable extradition treaty, we do not consider it appropriate just to add the United States-New Zealand Treaty definition to the section 4 definition. We consider that the test in Article 2 of the United States-New Zealand Treaty replaces the test as set out in section 4, instead of merely being added to it, especially given the added subject to qualification in section 4 itself. And then the court goes on to say the proper inquiry for a court faced with an extradition request made by the United States is therefore whether the alleged conduct satisfies the requirements of the United States-New Zealand Treaty, and the court should no longer concern itself with the three-stage test that has been utilised to date in this case. Now, The problem with that is that the court seems to be overlooking the fact that in section 24(2)(c), the wording is the offence is an extradition offence. There's no conduct element in section 24(2)(c). The conduct element comes from section 4, but the court has held that the treaty replaces section 4. So where does the conduct test come from if it's not from section 4? We can then go to section 5, but that's dealing with a different issue. That's dealing with the conduct constituting an offence, which is the wording from section 24(2)(d). So there's a distinction which has been elided in Cullinane, which seems to go from the offence to the conduct constituting the offence, which doesn't seem to be consonant with section 24(2)(c). Now, I'm not submitting that Your Honour has to overrule the Court of Appeal, obviously, and what Cullinane says is what it says. But it is a little difficult to follow the logic of the judgment at that particular point. Be that as it may, section 24(2)(c) is a crucial step. It's an absolutely crucial step, and we say that the district court judgment doesn't grapple with the Cullinane analysis. On the contrary, that analysis is avoided. And there are some significant indications in the judgment, which we'll come to, which indicate that His Honour has simply not understood properly what is supposed to happen at section 25, at the section 25(2)(c) stage.
24(2)(c).
It's 24(2)(c)
Yeah.
stage. Now, nobody could blame His Honour for being confused about that issue if he was, because it's a difficult point. And the whole logic of the Cullinane reasoning may have to be revisited at some stage at the appropriate level. And we're not asking Your Honour to this is part of the, on this point, it's part of the ratio of the case, and we're not asking Your Honour to depart from it. We're simply saying, first of all, there's a logical difficulty in terms of the internal structure of the statute. And secondly, what test has His Honour applied at that stage? Because it's a crucial step in the reasoning process.
Yeah.
Now, we've just drawn your attention to the US case and the table which sets out the what the US says are the relevant extradition offences. Making that correlation and doing it appropriately is crucial. Now, if, for example, there had to be a tighter equivalence than is specified in Cullinane, that would be a significant matter in determining the jurisdiction of the court. But for present purposes, we proceed on the basis that what Judge Dawson needed to look at and what Your Honour needs to look at is the conduct that constitutes the offence for the purposes of this issue, even though that wording is actually drawn from 24(2)(d), not 24(2)(c). I hope I've made myself clear on that point. So at page 8 of these submissions, sir, we outline our case and the key points that we are making in response to the US case. And of course, we are saying at C that the US offences did not amount to extradition offences. And whatever the rights and wrongs of the statutory interpretation point, that step is a crucial one and has to be done properly. Now, starting at page 9, we deal with the judgment. And clearly, Your Honour needs to read these submissions with the indictment, and I'm not going to go through that excruciating process, but we do make our key points in relation to each count, and we invite Your Honour to consider those points in relation to whether His Honour did the necessary analysis, and we say that that analysis wasn't done or wasn't done adequately. And you'll see, for example, at count 1, there's no actual finding to the effect that count 1 amounts to an extradition offence, although it can be considered to be implicit from the fact that the judge goes on to consider whether there's a prima facie case.
Yeah.
But one would expect normally that there would be a section of the judgment in relation to each count to analyse whether or not that count in the indictment represents an extradition offence under our statute. And that, with great respect to His Honour, wasn't done. There are sections of the judgment which we'll come to, which can be brought into account in relation to these issues.
Yes.
And in fairness to His Honour, we need to refer to those as well. But in terms of each count, we say there is little or no analysis to make the equivalence test, or to analyse the equivalence in relation to the count in question. Now, the point that there's no actual finding about correlation is made in respect of several of the counts, not all of them. But when His Honour does say that there is correlation, it's just a brief statement to that effect, without any analysis in relation to the substantive issue. Now, at the end of the discussion of those counts on page 16, we refer to the fact that His Honour hasn't made a finding, this is at paragraph 22, about the requisite supporting documents. His Honour seems to have overlooked that step, although I guess it's implicit in the judgment, or can only be inferred. Then at 6, 7, 8, His Honour finds that there's a prima facie case for each count in the superseding indictment, but then goes on to say the respondents are entitled to challenge the applicant's case and do so, and those challenges are considered below. So the logic of the judgment seems to be, there's a prima facie case made out, now we'll consider whether there are any challenges that should be should undermine that prima facie case.
Rather than looking at the whole of the evidence and making a decision on that basis.
Exactly, that's the holistic point that I referred to previously. And so His Honour then goes on to consider what he understands to be the plaintiff's defence, and we set out what His Honour looked at the bottom of page 16 and over onto page 17, and we in our submission, sir, that was an inadequate consideration of the arguments that we had raised, which were much more extensive than than what His Honour said. And then the other arguments are dispatched to the rubbish bin at page 27 by His Honour saying that other matters were not relevant to the other matters argued were not relevant to the decision given. In terms of the evidence, top of page 18, His Honour said that the overwhelming preponderance of evidence produced by the applicant in the record of case and supplementary record of case establishes a prima facie case to answer for all respondents on each of the counts. So that's a global determination, but we will demonstrate as we go on, sir, that that's not what the law requires, and what the law does require is a question of whether there's evidence to support each essential ingredient of the charge.
Does the notation SROC there bring in SROC 8?
No, sir. There were. What happened was that at the very beginning of the case, there was a record of the case bundle, and then over a significant period of time, and we can give it'll be in the chronology.
Yes.
There were 7 supplementary records. Now that was down. So as at the start of the hearing, the court had 7 supplementary records of case.
8 came in reply submissions.
That's right.
But all I'm really just trying to understand is when the judge refers to SROC here, ROC and SROC, is he? Do you understand him to be incorporating all aspects of the supplementary record of case, including 8?
No, we don't know, sir.
You don't know?
We don't know.
So that's not an indication that he has or has not taken into account.
No, because there were 7 supplementary records, and we don't know whether. In fact, he says SROC. I mean, it should be SROCs.
Right. Yeah.
But that's a pedantic point. But it
must include 1 to 7. It's just silent on whether it also incorporates 8.
Exactly. Yes, sir.
But the likelihood is it does.
Well, we think it does because His Honour referred to a conflict of expert testimony.
Yes.
And we wouldn't have got that
unless SROC 8 had been taken into account. Yeah.
In effect, he's saying Professor Salas only gives an alternative explanation. It's a matter for trial because we've got a conflict of expert.
It's been answered by the material in reply. Right, okay. Thank you.
So in the next section, we deal with basic judicial review points. So we identify the statutory powers.
Yes. We
identify the grounds of review as we did in exactly the same way as we did for the July and August stays.
Yes.
We then deal with the question of breach of natural justice. I need only say, sir, that what we're saying here is that because we didn't get the stay orders that we were seeking, we were forced to go into the eligibility hearing itself under the handicap.
Yes.
And we detail the natural justice points down to page 21. And more specifically at 21, starting at paragraph 37, we deal with the impact of the forfeiture decision on the actual eligibility hearing itself, and we give some details about how that impact was felt during the course of the hearing. And we say at 39 that the unfairness can be seen on the face of the judgment, because in finding the plaintiffs eligible for surrender, the district court criticised the plaintiffs either explicitly or implicitly for failures to adduce evidence or prove certain matters, despite the fact that we'd been prevented from bringing that evidence. And so we give examples of that in paragraph 40. So in relation to Professor Salas, his evidence does not undermine the evidence of the record of case to the extent that the record of case evidence is unreliable. Well, could that have been said? if we'd had proper expert testimony on the architecture and methodology of mega upload. At B, none of the submissions made individually or submissions made, if considered in their entirety, come close to establishing a breach of the duty of candour and good faith. We were asking for an opportunity to be able to challenge the US on that issue. We'd been denied that opportunity because of the spending barrier, and His Honour is now criticising us for failing to prove the very thing that we were complaining that we'd been denied. C, making allegations without an evidential background do not provide any basis for establishing a breach of the duty. Well, denial of opportunity not recognised. And then in D, a number of the submissions were unsupported by properly sworn evidence. That's what we wanted to be able to do. So His Honour is in the eligibility decision itself, as distinct from the stay phase of the proceedings, is criticising the extradition defendants for a failure to adduce evidence when the defendants were saying we can't get access to that information. And so we make the point at 41 that that's self-evidently unfair. And then, still under the natural justice heading, we contend that His Honour failed to undertake a meaningful judicial assessment. And that's, of course, based on the Ferris principle. And so in support of that, we say that the District Court's analysis under 24.2 covers only 35 pages of the 271-page judgment. Aside from one brief mention, it is silent as to the plaintiff's arguments. It is followed by an 11-page section which purports to address the plaintiff's submissions that challenge the applicant's prima facie case, and we'll be showing, sir, that section is flawed. There is no acknowledgement that the plaintiffs made any arguments under 24.2c. And so we'll be looking at the prima facie case stage later, but for present purposes, the key point is why is the judge not addressing arguments in relation to 24.2c? The one mention of the plaintiff's submissions in the 24.2 analysis relates to count 4, which alleges one specific act of copyright infringement, and that's alleged to have been an act on the part of Mr. van der Kolk. Specifically, the United States alleges that in October 2008, Mr. van der Kolk distributed a copyright work, which is said to be a film named Taken, prior to it being commercially distributed in the United States. Now, there are a number of issues about that particular count. In response to that charge, we had made certain submissions, and I'm not going to go through them all, sir, but our submissions are summarised on page 23. And there was a substantial and serious argument, as you can see from those summarised submissions, about that issue. In particular, I'll just mention one point, which is at Little Roman 2. The allegation that Mr. van der Kolk uploaded the movie in question was apparently based on an unidentified email, the content of which was not disclosed by the United States. But in any event, those submissions go onto the next page.
So do you say that was the only factual foundation for it? Evidential foundation, I should say.
If I can come back to Your Honour on that, sir, that it apparently is a little bit more complicated than that alone.
There's nothing straightforward in this case.
No. But what we were submitting is that the factual foundation was weak. And essentially what we're saying for present purposes, sir, is that these detailed arguments which you see
But not addressed.
Exactly. Now, I'm not sure if Your Honour's picked this up, but if you go to count 4 in the indictment, and perhaps we should go to that, in this case, go to the actual count. So this is in our key documents bundle at tab 4. And count 4 is at B0316. Now you'll see, Your Honour, that this is a charge of criminal copyright infringement by distributing a copyrighted work being prepared for commercial distribution on a computer network and aiding and abetting criminal copyright infringement. That's the heading and US section references are referred to, including Title 17 of the US Code at section 506, which is the main copyright offence provision. And so all of the extradition defendants are included in the list, and it then says that including of course Mr. van der Kolk, and it says that the defendants did willfully and for purposes of commercial advantage and private financial gain infringe a copyright by distributing a work being prepared for commercial distribution in the United States, to wit, the copyright motion picture Taken, which would not be commercially distributed until on or about 30 January 2009, by making it available on a computer network accessible to members of the public, when the defendants knew and should have known that the work was intended for commercial distribution. Now, the allegation, and you'll see that that's all in violation of Title 17, etc. The allegation is a breach of, a substantive breach of copyright with an aggravating feature, which is that the work was being prepared for commercial distribution and that particular work would not be commercially distributed until on or about 30th of January 2009. It transpired, Your Honour, that we found that the movie which it was alleged to be the subject of the charge, in fact there are a number of different movies called Taken, but the one that was alleged to be the subject of the charge had in fact been distributed in numerous countries, I think from recollection about 30 different countries, before the date that the
before 25 October
25
2008.
October, that's correct. And we submitted evidence to that effect. So that was one aspect of the defence argument. And the rest of our argument is set out, summarised on page 23, 24 and 25. Now you see in the judgment concerning that particular count that His Honour refers to the submission and includes the point at item 3 as at 25. He's saying at his paragraph 647, it's submitted for Mr. van der Kolk 1, 2, 3 as at 25 October 2008 taken had been released to cinemas in 30 countries worldwide. And His Honour does record that Mr. van der Kolk was, there was no evidence that Mr. van der Kolk or the recipient was located in the USA. The file was uploaded by users in the United States prior to its release in that country. But then His Honour says whether taken was commercially available in certain countries and when that occurred doesn't necessarily mean that the copyright owner of taken did not have its property rights prejudiced. It could still be downloaded, distributed illegitimately in contravention of the copyright owner's property rights, etc. Now, in our submission, sir, that was simply not a proper or adequate assessment of the submissions that we'd made. If you go back and look at the submissions that we'd made, it simply doesn't deal with them. And in particular, it didn't deal with the fact that the United States hadn't acted with appropriate candour in relation to that issue, because we had, the United States must have known, or should have known, that the movie that it was relying upon for that charge had in fact been released worldwide, although not in the United States. When I say worldwide, in many countries throughout the world. It hadn't disclosed that fact, and the exacerbating factor had been added to bring the charge into the 4-year or more category required for a deemed offence under 101B1C.
So those are the words in parentheses.
Yes.
They're required, are they, to elevate the seriousness of this offending to a level that's punishable by 4 years or more?
Well, it's not just the words in parentheses. So if you look above, those words are giving the particulars.
The being prepared.
They're giving the particulars for this particular movie, but the charge also says that infringe our copyright by distributing a work being prepared for commercial distribution in the United States.
Yes. So those words amplified by the reference in the parentheses.
Yes, sir.
And without that, you say it doesn't come to the 4-year threshold.
On our understanding of the US provisions, without the help of an expert, we say that would be a provision.
That wouldn't be an extradition
It wouldn't be
offence.
a 4-year or above provision.
And therefore not an extradition
And therefore
offence.
not a deemed offence under 101B1C.
Yeah. Is that common ground, do you know?
No, sir, I doubt that it is. We don't have...
Not much common ground.
There's very, very little common ground, sir.
Right, okay.
The name of the case is agreed.
All right.
So that's an example of where a detailed argument on one particular issue has been summarised down to something much less than what we were actually arguing.
It may not matter whether it's common ground. The point is that that feature is a critical part of the alleged offence.
That's right.
So it doesn't really matter whether it's
No, it doesn't.
otherwise would have been another extradition offence. What matters is this particular count an extradition offence?
That's right.
Right.
That's one aspect of what matters, sir. The other aspect of what matters is did the United States.
Oh, yes, I understand the candor point.
And we come to the
But
candor
in terms
argument
of the
that it's a
analysis
separate
under section 24.2c,
issue. That's right.
Yeah.
We're now looking at 24.2c. So we say that a similar approach applies, and I'm now at our paragraph 48 on page 26. And we say that the way in which the judge addresses our arguments was deficient, and we set out what His Honour appeared to consider was our argument, or were our arguments in relation to eligibility, which is an extremely simplified and indeed incorrect summary. You'll see very shortly, Your Honour, that for the purposes of this hearing, we basically set out the same arguments in relation to 24.2c that were addressed in the district court.
yes. We've mentioned this a number of times now. I mean, you've invited me to accept, and I understand if there's no contest on this from counsel, that I should work on the basis that the submissions that are presented here that are relevant to whether it was an extradition offence and so on are in all material respects exactly the same submissions that were advanced in the district court. I mean, it may be important because for judicial review purposes you're saying those submissions were not addressed. Now, I don't think I have the actual submissions that were presented in the district court. I may do, but...
you do, in fact.
I do. Oh, right. Oh,
and,
okay. Oh, well, that's fine. That covers that off.
I think Ms Gordon will probably agree that the submissions that were...
in all material respects.
We're recycling the submissions that we made in the court below in all material respects. We may have gone into a little more detail on some points, especially in our reply submissions.
Yes.
But so far as these submissions are concerned, they are indeed very close to what was presented in the court below. Obviously, with the exception of the criticisms of the judgment. Now, so moving on to page 27 and 28, we give you examples of arguments that were just swept aside and deemed not relevant, and we refer to that at the top of page 28, para 50.
Yes.
And then we refer thereafter to the question of engagement in the proceedings.
Yeah.
Now, really, I want to make it clear, sir, we do not say that a judge has got an obligation to engage with counsel and ask questions. Your Honour...
Well, if you answer every question that might be asked through the comprehensive nature of your submissions, I mean, I don't know how far this really takes me. I think it's a little bit like, I appreciate it's slightly different, but that point about where the judge was looking at different times and so on, I mean, it's difficult to make much of that. In this case, surely the safer course is to look at the judgment itself and see whether
We're accepting that, sir. The only point that comes out of this is that if His Honour was in doubt as to issues, then His Honour had the opportunity to answer the question.
Yes, of course.
But there is, of course, one...
Well, it was a 10-week hearing, wasn't it?
It stopped and started a bit, but it was extending over that period. And so it is unusual that His Honour didn't inquire of counsel a little bit more about the issues. But as Your Honour rightly says, the important point is the judgment. There is, however, one exceptional interchange, which is set out at the bottom of page 28.
Yes, I've read that.
Yeah, and that was surprising to say the least.
Oh, well.
Now, on page 29, we deal with the 8th supplementary record of case, and we've already dealt with that under the July stay argument. We deal with it in more detail here, but I don't need to read through those submissions. Your Honour has already got the point.
Yes.
But I simply draw your attention, sir, to the fact that the issue is explained from pages 29 to 38
Yes.
in more detail than what you've heard before. So
Yep.
the
No,
detail of it
I've
is
read
there.
all of that, thank you.
We then deal with the third ground of review, which is errors of law. Bottom of page 38, starting at 71, we say that the errors of law are extensive and that they've been divided into 4 categories. Errors of law as to the general approach to section 24, specific errors in relation to 24.2c, including the 101B issue and whether the US offences are in the superseding indictment are extradition offences. Then the 24.2d issue, including transposition, admissibility and prima facie case. And then a 4th category, other errors relating to the duty of candour, 24.2a and b, and the admissibility of reply evidence. Now, so we start on that topic in the middle of page 39 and invite Your Honour to look at paragraph 75. We say that His Honour misunderstood the section 24 analysis by emphasising the primary role of under 24.2d, the certification requirement, and that a requested person's defence was only relevant after the district court had already determined the prima facie case point. So it's the combination of those 3 points. What is missed out is the 24.2c analysis. And starting at page 40, we refer to paragraph 16 of the judgment in our paragraph 77. So His Honour misses out any significant reference to 24.2c. That the principal purpose point is repeated in the extract set out at the top of page 41, but there is a more detailed account in paragraphs 580 and 582 of the judgment, which are quoted at the bottom of page 41. Now, at first blush, 580 to 582 appear to be in accordance with the Act, except for the reference at 582 to extradition offences, section 24.1. But His Honour again skips section 24.2c, which, as we've seen, is a crucial step. And so our submission, sir, is that there's a missing link. Now, we can see the misunderstanding earlier on in the judgment, and we've set out that point at page 83. So In 83A, the District Court stated that Section 24(2) required the court to be satisfied that the US were extradition offences in the United States, and that the court could be satisfied of the same on the basis of the certificate accompanying the record of the case. Well, Section 24(2)(c) has got nothing to do at all with the Section 25 certificate. Then B, the judgment makes no reference to Section 4, which contains the definition of extradition offence, although we have to say that Cullinane says that the treaty replaces Section 4. But there's no reference to that Cullinane analysis, and so the query is, has His Honour understood the Cullinane point? And then likewise, Part C of the judgment, which does contain the eligibility analysis, contains no reference to Edwards or Cullinane, and I think there's another reference somewhere to the US offences being extradition offences in the United States. Is that the only one, or is there another one? We'll come back to that. But in our submission, sir, there's a missing link and an important item in relation to His Honour's understanding of extradition offence. We say it's a crucial step in Section 24. His Honour falls into error by referring to an extradition offence in the United States and saying that the certificate satisfies that issue. There's then no reference to Section 4 itself, no reference to Section 24(2)(c, and no reference to the Cullinane analysis in any material way. So it just leaves a big question mark as to whether His Honour has understood and followed the Cullinane methodology. There are apparently some references to 24(2)(c, and I'll come back to that after the break soon. So we've then set out what we say is the correct approach, but I dealt with that at the beginning of the case by reference to the Act and Cullinane, and Your Honour's already got that. So the next few pages go over that, the issue that was already covered at the outset of the case.
Yes.
We can then go through to page 46. The point we make here, sir, is that Cullinane clearly looks at the indictment as the primary source of information as to what constitutes the offence in the requesting state. And although we've got some issues over whether it's the conduct or the offence itself that's an issue, the indictment must be the primary source of information. And what we say is, if it's conduct, then it must be the essential conduct that constitutes that offence, not adventitious circumstances as it's been put in one of the cases. And so we come down to our paragraph 102. So 101, we say the court is required to identify the essential conduct with which a person is charged. As we've noted, the essential acts and omissions in relation to the US charge of conspiracy to commit copyright infringement can be deduced from the superseding indictment itself. We would have liked to have had help on that, but without that help, we and the court simply have to do our best. And we say that where the indictment incorporates by reference sections and definitions, it must be permissible to have regard to those provisions for the purpose of understanding the indictment. That is not for the purpose of assessing or implementing foreign law. That is what was done in Cullinane, and that's what we'll go on to deal with. But on that point, we've cited two cases, two Canadian cases, One is Mano and the other is Tavomina. And in both of those cases, the decision in McVeigh is discussed, and the question of whether or not all aspects of foreign law are completely eliminated. And the court in both cases made the point that in order to do the assessment that was required by McVeigh, it was still, even though McVeigh said that questions of foreign law don't arise, it was still necessary to look at the charge to see what the essential ingredients of that charge were according to the foreign law, and that even the McVeigh analysis didn't exclude that issue. Now that makes sense under our approach, because as we saw from Cullinane, the court did go to the indictment, the court did try to isolate what the essential conduct was, and then measured that against the treaty offence, and Mr. Cullinane walked free because the court said that conduct wasn't covered by the treaty category. So that demonstrates how important the analysis is, and indeed we set out the relevant extracts on page 49 through to 49 and 50, the extracts where the Cullinane court did exactly that, but I've already taken Your Honour to those extracts, and we don't need to do that again. Your Honour, the relationship between Section 4 and 24.2c, the Cullinane point, occupied a large part of the lower court hearing. The United States argued for a broad definition of conduct, and then sought to match the conduct against the ingredients of the essential ingredients of each pathway charge. Now, I'm not sure if Your Honour understands what I mean by the pathway charge, but I can clarify that if you wish me to.
Whereabouts are you at the moment?
I'm adding, this is not in this is a comment, sir, in relation to page 51, where we're going to look at what the district court did in this case. So we say that any form of Cullinane type analysis is absent from the judgment, and that the extent of the judge's reasoning under section 24.2c is as we've set out in the following pages. But in relation to that part of the argument, I'm submitting that the US were arguing for a broad definition of conduct, the broadest possible definition of conduct, and then matching the conduct against the ingredients of each pathway charge. So an important issue is how broadly does conduct get defined for the purposes of the 24.2c analysis?
Yes. This is the cherry-pick point.
Yes. Yep. Now, we responded by arguing for a narrower interpretation of conduct, and we emphasised the words, the conduct that constitutes the offence. But in fact, in 24.2c, conduct is not used. The conduct that constitutes the offence is not used, and it's simply the reference in Cullinane that I took Your Honour to before, which equates the offence with the conduct underlying the offence. The problem in relation to the judgment is that His Honour simply skipped that issue. He merely asserts correlation without saying why. Now, as I said earlier, it's a difficult point. There's no criticism to be made for a judge simply making a mistake. But we say it goes further than that, because we say His Honour didn't attempt to analyse that particular step, and because it's a crucial step under the statute, that brings the whole judgment into question. It was a highly contentious and hotly fought issue. No reasons means no assessment, and a meaningful judicial assessment was crucial on that point because it is both jurisdictional and mandatory in the true sense of that word. So you'll see at paragraph 110 our submission that any form of colour name type analysis is absent from the judgment, that the extent of the judge's reasoning under section 24(2)(c) is as we've set out, and we say that it's insufficient to enable this court to be satisfied that the proper approach was adopted. If Your Honour goes down to page 55 at R112, we submit that, as you can see from the extracts that we've set out in the previous pages, the District Court made no attempt to identify the essential conduct described in this superseding indictment or to undertake an interpretational exercise to ascertain whether the alleged extradition offences covered that essential conduct. Instead, His Honour seems to have accepted that all of the counts in the superseding indictment were covered by all of the extradition offences alleged by the United States without explaining sufficient reasons for doing so. And of course there's the certificate, section 25 certificate, which is the fly in the ointment in relation to that issue as well.
Did all parties attempt to identify what the essential conduct was on a count-by-count basis?
Yes, we did.
So there was a lot of dispute about what was covered, with you taking a narrow approach and the United States taking a broad approach to this issue. But none of that's referred to in the judgment, the competing contentions on that.
That's right.
And that occupied quite a significant part of the hearing.
It was a huge part of the hearing. I would have thought that from a friend's point of view, most of her volume 1, there were 2 volumes of US submissions, and just from memory I would have thought that most of her volume 1 was dedicated to trying to match up the counts in the indictment with the pathway offences. So basically the idea is that the count in, say, count 2 is the obvious example. A count 2 in the indictment, conspiracy to commit copyright infringement, matches up with Article 216 or particular provisions of the Crimes Act, and those are the different pathways that can lead to the conclusion that an extradition offence has been alleged, which is the 24(2)(c) step. Now, if that analysis hasn't been followed by the court and ruled upon in terms of the arguments and the counter-arguments, then where's the meaningful judicial assessment on that point? And the confusion over the resolution of that issue is evident from the points made at the top of our page 56. His Honour, at one point, this is paragraph A at the top of the page, His Honour says that there is evidence before the court sufficient to establish certain matters, then goes on to say that the conduct alleged in count 2 therefore translates to a deemed extradition offence. Cart before the horse, we submit. Then at the second, in paragraph B, there's a reference to His Honour saying that the evidence in the record of case alleges a plan to deceive copyright owners, and His Honour goes on to say at the next paragraph that the alleged conduct translates into a treaty offence under Article 216. And then again in our paragraph C, the judge refers to a submission by the applicant, in other words, counsel submissions, that the alleged conduct in counts 9 to 13 involved certain things. Those submissions are set out, And His Honour then goes on to say that the alleged conduct satisfies the elements of an offence under 240 and qualifies as a deemed treaty offence. So there's a lack of consistency in isolating the information upon which the assessment of extradition offence is going to be made. So, in a nutshell, we submit at paragraph 115 that the District Court did not appreciate what was required of it under section 24(2)(c), failed to understand and apply the correct analysis, and therefore this court can't be satisfied that the District Court findings were correct in law.
It's a long way away from considering available inferences. Presumably the submissions address not only what was contended for as the relevant underlying conduct, but also what inferences could properly be drawn in relation to that.
Yes, sir, but that's at the next stage,
Yeah.
which is the 24(2)(d) analysis.
Yes, but wasn't it all wrapped up together in this judgment or not?
Oh, I see what you mean.
Because you're really sort of saying, well, you're presuming that they've got through the 24(2)(c) because going on to address the sufficiency of the case under D. Or have I got that wrong?
Well, sir, I haven't focused on the question, and I'd need to come back to you after the break, sir, as to whether or not His Honour is including inferences in relation to the question of whether there's an extradition offence. That's a difficult question to answer on the hoof, and if I can just
Yes.
park that for the moment. What we're saying here, sir, is that His Honour is looking at the evidence, he's looking at the submissions. In other words, he's going to the actual body of the evidence to see what whether or not the particular pathway charge that is under consideration falls within the extradition offence category. So there's a confusion at this point in time, at this point in the judgment, in relation to the section 24(2)(c) analysis.
Yes.
And really that's as
Well,
far as
that's the point. Isn't that the point that you're making in 114? The cart before the horse point?
Oh, yes. Yes, that His Honour is actually going to the evidence.
Yes, jumping over the first question as to, well, what is the conduct?
Yes.
And if it has all been rolled up in that way without a discrete analysis first of whether there is an extradition offence before then turning to the sufficiency of the evidence, you're getting you're a long way away from analysing it in the sort of level of precision that you were inviting with consideration of availability of inferences from the evidence. But
well, in our submission, sir, to look at the evidence in order to see whether there's an extradition offence, short circuits the statutory text.
Exactly, yeah, I understand the point. Because the starting point is to look at the indictment, isolate what the relevant conduct is as asserted in the indictment, and then consider whether that's an extradition offence. That's before you start looking at the evidence.
That's our submission, sir, but I have to say that I understand my learned friends take a different view.
Yes.
And they say that you can look at the whole gamut of the documents that have been submitted to see whether the totality of the conduct that's alleged falls within the treaty offence. But what that means is that you're using the same body of material to determine whether you've got an extradition offence, and then when you go to the prima facie case stage, of course you're going to make out the extradition offence because that's what you've used to define the offence in the first place.
Yes.
So we say it is a short-circuiting of the statutory test, and we say that it can't be the correct approach And even though Cullinane extends or gives a broad reading to section 24.2c, it can't be that broad. Otherwise, the logic of the statute doesn't make sense. So, Your Honour, we now come on to 24.2d, which is the prima facie case issue. And we set out our key points at the bottom of page 56. Under that heading, failing to weigh the evidence, failing to assess the evidence against the elements of the extradition offences that the court had identified, and failing to assess the evidence against the extradition defendants individually. Now, these are reasonably straightforward arguments that I'm not going to dwell on. I'm not going to read out every passage, but in relation to the first point, you've heard the reference to Ferris and the obligation to give a limited weighing to the evidence and to give the prima facie case issue a meaningful judicial assessment. But His Honour appears to take a much more limited view on the issue of weighing the evidence. So you'll see that on our page 58. There's reference to a case at the top of the page called Ortmann. If I can just pause for a moment. We haven't given Your Honour the benefit of a date for that case, and I'll just give you that in a moment. So Ortmann takes a very narrow view to weighing, and His Honour at paragraph 18 says, although this court is not required to weigh the evidence, it does have the discretion to reject evidence that is manifestly unreliable. So there's a specific reference to the court not being required to weigh the evidence. The Ortmann case is 1989, so it precedes by a very long way. It precedes McVeigh, it precedes Ferris, it precedes the Dotcom references, and it is indeed a completely out-of-date case by the time we argue the matter in the lower court last year. But His Honour does quote Ferris in the next paragraph, but he doesn't refer to the passages about meaningful judicial assessment and the limited weighing of the evidence, which completely contradict what he has said in paragraphs 17 and 18. And then there's reference to Tomlinson, an Ontario case which is 2007 and does follow Ferris and seems to be a correct interpretation. It matters not whether the case against the person sought is weak or whether the prospect for conviction unlikely. The ultimate question of guilt or innocence is for the trial court in the foreign jurisdiction. But it does, again, miss out the key Ferris point about meaningful judicial assessment and the limited weighing of the evidence. And so we submit that the district court was wrong to hold that it was not required to weigh the evidence before it. And in any event, we have ample law in New Zealand on whether on the question of whether there's a case to answer and whether or not a matter can be sent to the jury. And so we refer to the New Zealand cases, Court of Appeal decisions in Flager and Paris, and they are the law of the land here. And we say it's correct that the analysis doesn't require the judge to preempt how much weight a jury might attribute to certain pieces of evidence. but to the extent that the judge must be satisfied that the evidence is reasonably capable of supporting a conviction, the judge is required to weigh that evidence. And so the reference in paragraph 18 that the court is not required to weigh the evidence in our submission, sir, is a matter for concern. We then go on to quote the Ferris excerpts, and I don't need to dwell on those. You've heard that material already. I can go down to page 61, where the point, the extent of the weighing exercise is picked up in a British Columbia case called US and Graham. It's a 2007 case, and there's also another case called Scarpiti. And the court, in a case called Hislop, I'm sorry, sir, I missed out the reference. The case that we're actually looking at is referred to at the bottom of page 60, paragraph 132. It's USA and Hislop, 2008 British Columbia case. And in the Hislop court cites a passage from Graham, and the court says, I find myself in respectful disagreement with the passage that's then quoted, which includes the underlined words, there is no power to deny extradition in cases that appear to the extradition judge to be weak or unlikely to succeed at trial. And the judge then says, my difficulty with that way of putting the limit of discretion is that there are degrees of weakness, and extradition judges should not be put off their task of assessing for sufficiency by a dictum that mere weakness is not enough. I agree that it's not enough. It may be more helpful to speak in terms of the test for reviewing verdicts for unreasonableness on appeal or directed verdicts and so on. So the idea that a court doesn't engage in any weighing in an extradition context is simply wrong. It doesn't try to determine what the outcome will be at trial, but there is a limited weighing involved. And
but is it any different from Flyger in Paris?
No, sir. I think
I mean, if it'd be unsafe, any verdict would be unsafe. It wouldn't be right to put it to the jury. There wouldn't be a prima facie case.
Yes, sir. We deal with Flyger just over the page, and we'll turn to that.
But
now.
all I'm really asking is, do these authorities really make any material difference in this case, or are we not just applying the fairly familiar Flyger and
for New Zealand? For New Zealand purposes, there's no need to go past Flyger and Paris. They set the standard for a case to answer.
And the standard seems to be much the same, isn't it? As is referred to in
but
Hislop.
What these cases helpfully do is tease out some issues so that they're a little bit more on the table. But if Your Honour goes to our page 63, under the heading of failure to assess the evidence against the elements of the extradition offences, we refer to Ferris and say that approach was also adopted in Flyger, in which the Court of Appeal was considering among other things an appeal against a district court judge's decision to dismiss the defendant's application under the old section 347. The Court of Appeal compared the 347 analysis to the consideration of whether there's a prima facie case, and said that the same judicial approach was required. The court went on to quote the Privy Council in Hortuatau, in which their lordships were considering the role of a judge at the conclusion of the prosecution case, and the test from the Privy Council cases is set out. So the court, and the underlined words in the middle section, as decider of law, the judge must consider whether there is some evidence not inherently incredible, which if he were to accept it as accurate, would establish each essential element in the alleged offence. Now, an impressionistic or just Gestalt approach is not adequate. The court needs to look at the essential ingredients of the offence and make a decision as to whether the evidence supports those ingredients, and we say that hasn't been done. So at the top of page 65, we make the point that there was no attempt to do that in the judgment, and we give an example starting at 143 in relation to section 131 of the Copyright Act. Then at 67 we say that an example of His Honour ignoring the elements of the extradition offence altogether can be found in relation to count 6, and the reasoning is set out over the next few pages. And so you'll see here we start to get into the question of copyright and copyright infringement. His Honour says, and take the first one as an example, a particular copyright infringing file with a single unique MD5 hash embodying a motion picture Ip Man 2 was downloaded, etc. Now, Ip Man 2, as we understand it, is a movie that was made in China, so it's not exactly clear how US copyright applies to that movie. And where does the judge get the evidence that it's a movie that enjoys copyright status, or that the computer file in question was a copyright infringing file? And you'll see, sir, that the allegations made by the United States are simply taken at face value on the basis of assertions, conclusory assertions, based on information that hasn't been disclosed. And similarly with the other 3 movies that are referred to. And as we say at the top of page 69, on that basis, that is the basis of those analyses, the District Court concluded that a prima facie case had been made out in respect of all of the extradition offences. Essentially, His Honour was satisfied that there was prima facie evidence in respect of 4 distinct extradition offences on the basis that he was satisfied of prima facie evidence of 5 infringing files being accessed on Mega Upload, and that was simply not adequate to respond to our arguments on the point. What it means is that His Honour failed to weigh the evidence for sufficiency and failed meaningfully to consider the evidence against the elements of the extradition offence. And we submit that constitutes an error in relation to the section 24(2)(d) issue. We then deal with the failure to consider requested persons individually. I don't need to dwell on that point. We then come at page 71, to the failure to address sections 24(2)(a) and (b). As Your Honour will appreciate from the section, those are prerequisites to the exercise of jurisdiction, but His Honour didn't consider those points in any sufficient way in the judgment. Your Honour, we now come to a section which deals with specific errors of law arising under 24(2)(c), and as we've seen, that is the question of whether the offence is an extradition offence in relation to the extradition country, and the court must be satisfied of that requirement. It's an essential step. Now, from there on, the points we make are self-evident from the written material, and there's no need for me to elaborate on those points. And so we invite Your Honour to read from page 72 to page 136, which deals with that section 24(2)(c) analysis in terms of applying section 24(2)(c) to the facts of the case, without me going through that in detail.
No, there's no need to do that.
You'll note, sir, section paragraph 166 on page 72, our disclaimer because of the funding issue. But we go through each count in the indictment, and we argue, as you've heard, that the extradition offence test is not met.
So that's pretty much a replication of what was before the district court.
Absolutely, yes, sir. His Honour simply took it at face value the submission for the United States that every count in the indictment and every pathway offence was available, with the one exception of
The statute barred.
Yeah.
Yeah.
Now, there is a section that Your Honour might want to look at in particular. I'm not going to go through it in detail, but on the question of dual use technology, and the important point for present purposes is that, I think we may have mentioned this earlier, sir, that there was a case in the United States called Sony Betamix, where what was an issue was a video cassette recorder that had 2 slots instead of 1, I think was the situation, which meant that you could copy from one to the other. Now the question was whether providing dual use technology was of itself a way of facilitating breach of copyright. And there's a whole section on dual use technology starting at our page 90 and going through to page 93. But otherwise we are focusing on really the question of correlation between the count in the indictment and the pathway charges that were being proposed by the United States. And so I think we can move forward then to the prima facie case analysis, and I'll come back to that after the break.
All right, thank you. We'll adjourn for 15 minutes.
Oi, kokia tuko tonu narata, ko is adjourned. now reopened.
Housekeeping matters, sir. As Your Honour is aware, there's a swearing in this afternoon, and we're actually doing very well in terms of timing, sir. So I don't know whether Your Honour wants to press on or not, but I think there are some counsel who might want to go to the swearing.
Yes. Well, thanks for raising that, because I was considering whether I'd be able to attend it as well, but I mean, the priority, of course, is to ensure that we complete this case. So if all counsel are agreed that we are making good progress, and counsel do wish to attend, or some do, then I'm quite happy to accommodate that.
Well, that would mean we'd adjourn at 3:15, something like that, sir.
Yes.
Which would mean we get an hour after lunch, or maybe an hour and a quarter.
Yes, we could start at 2.
Start at 2.
If that suited you.
Yeah, I'm happy with that,
You're
sir.
the one carrying the load at the moment.
Well, it certainly wouldn't be
All right. Well,
unhappy for me to have an early break today, sir, so that I can have the weekend to just complete the task.
yes. All right. Well, that's fine. Are all counsel agreed that we can do that? So, all right. We'll start at 2, and therefore we'll adjourn for the day at 3:15.
Thank you, sir.
Thank you.
Now, there are a couple of other things. Your Honour, we said we'd come back to you today with a chart in relation to the August
Yes.
stay. We tried to deal with that matter overnight, Your Honour, or more particularly Ms Hyde did. And
It's not critically urgent.
no, well, the situation turns out to be more complicated
than you thought.
than we thought.
That's all right.
So we'll come back to you on Monday with that.
Yeah, well, that's fine. At any point during the course of your submissions will be fine.
Thank you, sir. And also the decision tree, we will also endeavour to do that over the weekend, sir.
Yes. Okay. That's great. Thank you.
So, Your Honour, we're now on page 136 of volume 3, and we're dealing now with the prima facie case issue.
Yes. Can you just give me a moment?
Sure.
What page are you on?
136.
That's not me.
Yes. Thank you.
So at 490, we identify our overall submission, which is first that assuming that the District Court was correct to find one or more extradition offences, notwithstanding our arguments, we say we deny that, but then in that event, the District Court erred in law in finding a prima facie case in respect of any of those extradition offences, and our reasons are as follows. The record of case and supplements we submit do not comply with the requirements of the Extradition Act and are admissible for that reason. Alternatively, only those portions of the record of case constituting a summary of evidence for the purposes of Section 25 should have been considered by the court, and all extraneous material should be excised from the record of case. Even when shorn of the extraneous material, the remainder of the record of case contains evidence which is unreliable or insufficiently probative to be taken into account. And then, even if the evidence contained in the record of case could be relied upon, notwithstanding our objections, then the evidence nevertheless fails to establish the key elements of the alleged extradition offences, including in particular breach of copyright, and therefore no prima facie case is made out. The general problem is that the district court has not indicated what evidence it has relied upon in respect of its findings, other than in respect of the wire fraud counts, nor has it given any indication that it has weighed the evidence as required. And so we submit that the approach in the judgment is obfuscatory and opaque, and that makes review or appeal challenging, and we identify those issues. So the first question is the admissibility of the record of case, and we submit that well, first of all, the judgment is silent on on that issue, despite submissions that were made, and our submissions were implicitly rejected, but not actually discussed. And so our first submission is that the record of case doesn't meet the requirements of Section 25. Section 25, subsection 2, requires a record of case to contain a summary of the evidence acquired to support the request. So there are three important points there. First of all, it must be evidence. Secondly, it must be a summary of that evidence, and the evidence must have been acquired. And then subsection 3A requires an affidavit which includes a requirement that the evidence has been preserved for use in the person's trial. So again, reading acquired and preserved together, it's clearly material that has to have been obtained prior to the record being submitted. And then the 3B requirement is the certificate, which discloses which includes an opinion from a qualified person to the effect that the record of case discloses the existence of evidence that is sufficient. So we've got three indications that the evidence has to exist and to be preserved in those three parts of Section 25. And in our submission, it's clear that there's got to be a process of acquiring, summarising, preserving, etc. Now, in summary, our admissibility points are set out in 495, that the record of case doesn't comprise a summary because of the large volume of inadmissible material it contains. Mr. Prabhu's affidavit relating to the preservation of evidence for trial has been rebutted because of evidence that expert evidence that material on computer servers will degrade and be unavailable if steps aren't taken to keep it in proper conditions. And thirdly, the certificate that the record of case discloses the existence of evidence sufficient to justify a prosecution can be impugned and is impugned in the present case. So we deal with each of those issues before dealing with the adequacy of the particular record of case in this proceeding. We need to consider the purpose of the record of case, what it must contain, and the consequences of deficiency. 25.2 provides that a record of case must contain a summary of evidence acquired, and then there's a second provision about other relevant documents, which in a way has been read down in the Supreme Court disclosure case. So we're really concerned with A. The record of case the record of case, provided that it contains the above and was prepared by an investigating authority or prosecutor in an exempted country, will be admissible if it's accompanied by an affidavit that qualifies with the section and a certificate. that qualifies within the section. It follows that an admissible record of case will contain a summary and must be accompanied by a qualifying affidavit and a qualifying certificate. Now, we then come to the requirement that of the summary of evidence. And it's our submission that the record of case must be such that a meaningful judicial assessment of the evidence can be undertaken. And so we turn to the Supreme Court decision, the majority judgment, and there we find the following. Finally, an extradition judge is, of course, entitled to decide that a person is not eligible for surrender if he or she is not satisfied that the prerequisites for surrender, including a prima facie case against the requested person, are made out. Parliament has recognised in the scheme of the Extradition Act the critical importance to the extradition process of the decision on whether the requested persons are eligible for surrender by allocating that decision to a court and requiring the district court to conduct the extradition hearing as if it were a committal hearing. The district court must undertake a meaningful judicial assessment of whether the evidence is sufficient to meet the threshold of a prima facie case. This inquiry is so significant a safeguard for the requested person in the extradition process that it is, in section 11.2, excluded from the overriding effect of extradition treaties. Now, we, of course, say that the Supreme Court has brought into play the fairest principle because the words are essentially taken from that judgment. We refer to Ferris again and say at the top of 142, an assessment of that kind could not fairly be undertaken without requested persons having the ability and the opportunity to call the reliability and therefore the sufficiency of the summarised evidence into question. And that point appears to have been envisaged by the Canadian Supreme Court when it explained the following. While certification, that is of the record of case, may provide a general indication of reliability, given Canada's reliance on the good faith and diligence of its extradition partners, it only indicates that the rules in the requesting state have been complied with and does not preclude the possibility of error or falsification. And then the second reference, the requirements for committal of their section 29.1, properly construed, grant the extradition judge discretion to refuse to extradite on insufficient evidence, such as where the reliability of the evidence certified is successfully impeached, or where there is no evidence by certification or otherwise that the evidence is available for trial. So availability for trial and insufficiency are identified as key points. And then there are other references about the sufficiency of sufficient indicia of reliability. And at 512, challenging the justification for committal may involve adducing evidence or making arguments on whether the evidence could be believed by a reasonable jury. So in our submission, Your Honour, where evidence is summarised to such an extent that it can't be assessed, weighed or considered in any meaningful way, it is more properly considered as an assertion or submission than summarised evidence. And we submit that such assertions or submissions should not be included in a record of case. If we go back to the raison d'etre of section 25, it was to eliminate the basic problem of the hearsay rule applying to overseas jurisdictions. And section 25 certainly eliminates the need to provide first-hand evidence in accordance with the usual rules of evidence. but it doesn't authorise sloppiness, it doesn't authorise vagueness, and it doesn't authorise inadequacy or insufficiency of evidence. What it requires is a summary of evidence, and that term in our submission has to be given a proper meaning and a proper legal interpretation. And so we see in the majority judgment, in the disclosure judgment at our paragraph 514, this reading of section 25 is not, however, consistent with its legislative history, which is an argument that was being discussed, which, as we shall explain, indicates that the purpose of the record of case was to permit a requesting state to rely on a summary of the evidence rather than its detail as the basis for establishing a prima facie case. The legislative history also demonstrates recognition that in this form, the record of case procedure would accommodate the differences between legal systems and the problems to which they had given rise in extradition proceedings. It is well established that the purpose of the extradition legislation and the international obligations on which it is founded call for contextual construction that accommodates these differences, rather than an interpretation that necessarily reflects New Zealand criminal law. So the purpose of section 25 is to enable evidence to be summarised without every detail appearing, and also to avoid differences, technical problems arising from the differences between different countries in terms of their rules of evidence. But as the rest of that disclosure judgment shows, the purpose of section 25 is not to eliminate the need to provide meaningful judicial assessment of the evidence. It's got to be the summary has to be sufficient to enable the court to give that meaningful judicial assessment to the evidence when considering the prima facie case point. So the lead judgment goes on to explain the origins of the record of case procedure in Canada, noting the mischief which it sought to remedy. So their honours say the Canadian approach to extradition required that the evidence presented to the extradition court was admissible according to the law of the requested state. Concerns had arisen over the failure of extradition requests made to Canada and the deterrent effect on some states in making requests because of the difficulties that were being encountered by the application of admissibility rules. Civil law states were particularly troubled by the requirement to prove a prima facie case by sworn or documentary evidence without inadmissible hearsay, the use of which is permitted in civil law systems. It was difficulties such as these that the record of case procedure was designed to overcome. Again, the purpose was not to put the evidence beyond the reach of proper assessment. So, yes, get rid of the technical rules of admissibility, but no, you don't put the evidence beyond the reach of the ability of the judge to assess. That would defeat the whole purpose of section 24(2)(d). And the court goes on to say, during successive Commonwealth meetings, Canada proposed changes to the Commonwealth scheme that would retain the requirement for a prima facie case, but allow requesting states to rely on a record of the case. This proposal, with some modifications, was incorporated into the Commonwealth scheme by amendments that provided for member nations to be able to make bilateral arrangements having effect in place of requirements for formal evidence establishing a prima facie case. And then over the page, under the amendments, a record of the case could be received by the extradition court. Its contents would include a recital of the evidence acquired to support the request for the rendition of the person sought. The record of the case would be based on evidence admissible in the requesting state, even where such evidence would be excluded in the requested state. and would be accompanied by an affidavit from the investigating authority who had prepared the case and a certificate from the Attorney General of the requesting party expressing the opinion that the record of case showed the existence of evidence sufficient to justify the prosecution. A person could be extradited if the extradition court was satisfied that the contents of the record of the case, along with any other evidence admissible in the requested country, were sufficient to warrant trial for the charges. States were not required to amend their extradition legislation in accordance with the amended Commonwealth scheme, but many have done so to a greater or lesser extent. And then the court goes on to outline the translation of that Commonwealth, that modified Commonwealth scheme into our country. So there's reference to the international context. There's reference to an explanatory note in the bill with reference to the Commonwealth scheme, and the reference at the bottom of that explanatory note, the effect of prescription is to permit those countries to submit evidence to New Zealand courts that would ordinarily be admissible under New Zealand law. This should make providing evidence sufficient to satisfy this prima facie case test somewhat more straightforward for those countries. So the court is still looking for evidence that satisfies the prima facie case test, but it doesn't have to be via the normal gateway under our Evidence Act. And at the bottom of the page, still from the judgment, the form of the evidence should be such as was admissible in the requesting country. Reliability of the evidence was to be the subject of certification by requesting states. A measure of trust would thus be placed in their investigating authorities during the process, but importantly, the overall requirement that the country requested to surrender a person be satisfied that the available evidence establishes a prima facie case remained a central part of what the nations agreed should be a requisite for surrender. In most instances, a court would continue to be required to scrutinise the evidence for that purpose. And their honours went on to conclude that the very purpose of the record of case process was to simplify the presentation of evidence by the requesting state, as is evident from its origins and development, as discussed. And we then have a quote from Sir William Young in relation to the evidence point. Sorry, the exhibits point. And the important part about that quote is His Honour's reference to the primary purpose. At the very end of that quote, he says, even though the primary purpose of the adoption of the procedure was the exclusion of domestic admissibility rules. So the key purpose of the ROC procedure appears to be to avoid requesting states having to comply with New Zealand rules of admissibility when submitting evidence. It's not an excuse to replace evidence with submissions or assertions that have no proper basis made out. A summary, of course, doesn't have to include every detail, but it does have to be a summary. Now, we then refer to a Canadian case called thru, and that is simply a case that illustrates the problems that were would arise if strict adherence to the hearsay rule was insisted upon. And we say at 522, clearly the thru situation was intended to be avoided by the record of case procedure, the emphasis is on removing technical procedural barriers. In that sense, it is a shortcut afforded to trusted allies such as the United States. But crucially, a record of case is not a device to permit a requesting state to omit key elements of what it must prove on the basis that a record of case is only a summary. The purpose is to avoid technical evidential issues. It is not an opportunity for a requesting state to obfuscate or avoid providing sufficient detail. So we now look at what the record of case should include. So the inclusion of commentary and explanations. And we acknowledge, Your Honour, that some commentary is permitted to be included in the record of case, but a distinction must be drawn between what is properly considered to be evidence and what is not. Now, this issue was discussed in a recent Canadian case of Chavez, and the arguments are set out on page 147, and the court says that the first part of the record of case, entitled Overview, provides an outline of the quote's story in the form of evidence and argument that it hopes to prove in the proposed trial in the United States. The Act and jurisprudence do not prohibit the requesting state from doing so. It is clear that the overview is not evidence and cannot be used as evidence by a judge considering whether a committal is allowed, unless the contents of the overview are supported by the evidence or inferences from the evidence summarised in the remainder of the record of case. And then at paragraph 20, a judge reading the record of case must ensure that summarised evidence is adequately sourced and that overviews and linking explanations are viewed merely as informational. Providing a clearly labelled overview as a roadmap is not prohibited by the Act. There is no requirement that every statement be sourced, and there is no restriction from making comments in a record of case. The record of case must be read as a whole, and the emphasis is on what can be established by the evidence. To argue every minute part of the wording and insist the state should only summarise evidence with nothing more suggests that a judge is unable to isolate the requisite evidence and look at the context of the offence alleged. So that last part is very important, because it is saying a trained judicial officer can distinguish between comment and evidence, and just to provide an overview is not objectionable, because the judge will determine what is evidence and what is not. So we acknowledge, as we've set out in our 527, that the requesting state is entitled in the record of case to give an overview or to make linking comments and explanations, but those comments must be supported by evidence located elsewhere in the record of case, must be viewed by the judge as merely informational, and must not be considered to be or relied upon as or otherwise treated as evidence. And comments should be adequately referenced to source. So, analysing the contents of the record of case becomes a very, very important exercise. And where there's a record of case that contains a large volume of material that is not a summary of evidence, that can take the whole record of case outside the scope of Section 25, because it's a question of degree. But if the record of case departs sufficiently from the concept that it should contain a summary, then it won't be what Section 25 authorises. And there, in an extreme situation, that can mean that the whole record of case becomes inadmissible.
Even if it does contain a summary of the evidence?
Well, if there's an abuse of the summary,
But the court is presumed to be able to differentiate between those parts of the record of case that are informational or really submission or whatever, and identify where the evidence is, or the summary of the evidence. So long as that's contained, can you really say that it falls entirely outside
what I'm
Section
saying, sir,
25,
is,
subsection 2?
what I'm saying, sir, is that in an extreme case, and we say that our situation is at least a borderline case, in an extreme case, it can, the authorisation that's given under Section 25 may not apply. It's a shortcut situation. It's a bit like the blood alcohol shortcut. If the authorisation, if the statutory authorisation is to an item that fulfills certain requirements, and the record of case falls so far outside those requirements that it can't be regarded as the authorised, as being within the authorised category, then the authorisation doesn't apply. Now that's a question of degree, it's a question of fact in every case. But if the court looks at the document and says this is just not even what Section 25 has authorised, then it's inadmissible. But falling short of that, what we're dealing with here and what we're acknowledging is that in the ordinary case there may be overviews, there may be linking statements, there may be commentary, but the judge is required to analyse and to differentiate.
Yes.
Now, what we did in order to try to assist the court in this present case was to provide a colour-coded version of the record of case. And that was the only sensible way to address the point, because trying to, if you imagine going through every paragraph and saying this is out and this is in, it would be a monumental exercise. We'd have 1,000 pages for that exercise alone. And so it seemed sensible to us, sir, to provide His Honour with some assistance. And the assistance we tried to provide was to present a colour-coded version of the record of case, including the supplements, such as we had at the time, and to identify with different highlight colours what appeared to be a summary, what appeared to be commentary or assertion or whatever, and to enable the judge to differentiate. Well, now, can I just have a moment? To the best of our knowledge, sir, I don't think that His Honour referred to that that colour-coded record of case at all. I may be wrong about that. I don't think he did. And certainly there doesn't seem to have been any attempt to differentiate between the summary material and the other material in the record of case. Now, we have and can hand up a copy of the colour-coded material, sir, so that you can see what we mean.
That would have been contentious, I imagine.
Oh, yes, of course. Everything's contentious in this case, but the point is that that's our argument.
Sure.
It's an argument that needed to be addressed.
Was there a colour-coded response?
No, there wasn't. No. But it might assist you on it.
Yes,
we're not asking you to, at this point...
Well, you say the task had to be undertaken.
Yes.
You provided assistance with it, and it wasn't grappled with.
That's right.
By the judge.
It's in the submissions. It's in the submissions.
Yes, there is some of it in the submissions, but that's not the right one. Oh, yeah. So we've got, actually, Your Honour, if I
It's
can
all
defer doing that until after the lunch break, I don't want to.
Well, is it from Appendix A, is it?
Well, yes, there is. We have got an extract in our appendix, which are examples.
That's Appendix A at 263?
That's correct, Your Honour.
Yeah.
So you'll see that.
So that's some of it, but not all.
It's some of it, but not all of it.
Right.
If we can just hold fire, I just want to make sure I'm giving you the right thing and understand it properly, and I'll do that after the break.
Right, okay.
But so, for example, if you go to 263,
Yeah,
you'll see that the green passages. Now, I don't have the key immediately to hand, but the green passages, without making concessions, the green passages were what appeared to be summary material, and the other colours were either conclusory assertions or commentary or that sort of thing. So you'll see in the yellow highlight, there's reference to copyright infringing video files, infringing content, and it comes up repeatedly. And so the key, as you'll see after the break, sir, there are three categories. So the orange refers to linking statements, commentary, and assertions, and that's the orange category. Legal submissions, conclusory statements, and submissions on the ultimate issue are denoted by the yellow highlight, and what appears to be a summary of evidence is coloured green. Now, when you see the whole thing, you'll see, sir, that there are vast tracts of the record of case that are in the yellow or the orange, or in some cases not highlighted because it's simply not clear what category it should be put in. But the green material.
Anyway, importantly, you say the only summary of evidence is the green.
Yes.
That's your submission.
Yes. And what that means, Your Honour, if we're right about that, and we think we are, is that the judge needed to say what material he was relying upon, and we gave him the assistance of having that colour-coded material to support our argument that some things were not within the summary of evidence category. And in particular, that applies to the question of copyright and copyright infringement. There were allegations throughout the ROC and the supplements to the effect that certain items were copyright items and certain items were infringing copies of copyright items. And we say that is an example of a conclusory assertion that can't properly be viewed as a summary of evidence. So coming back to the written submissions.
Yes, it's a summary of evidence, not a summary of the conclusions that are said that can be drawn from that evidence.
Yes, that's the exact point, sir, because otherwise assessment is put beyond the reach of the extradition judge.
Exactly.
The material doesn't have to comply with the hearsay rule or any other
No.
rules of evidence, but it does have to be something that can be assessed. And if a conclusion is stated, particularly a conclusion about a legal matter, such as copyright or copyright infringement, the court's has got to say, well, how do we know that? What's the factual basis for that? Now, this case has been said to be a very big copyright enforcement case, but if copyright isn't established and infringement of copyright isn't established, then it's a case built on shifting sand. And so that goes to the very root of the prima facie case issue under section 24(2)(d).
When it says a summary of the evidence, does that mean a summary of all of the evidence that's
No.
been obtained?
No, sir, we don't go that far. It's clear that in extradition proceedings, the requesting state can put forward such evidence as it thinks fit to justify the extradition. It doesn't have to be the whole of its case.
So the same as would apply here.
Yes. Yes, the record of case is an evidential shortcut. It's not a substantive shortcut.
No.
And that's part of the difficulty of having of saying that the signature on the certificate
Yes.
can't be refuted. Now I went to the back of my submissions and I just need to find my place again. Thank you. Yes, so we were looking at Chavez and the point that overview evidence is not, overview material is not evidence. The content must be supported by evidence or inferences, and the judge reading the record of case must ensure that summarised evidence is adequately sourced, that overviews and linking explanations are viewed merely as informational. And we say that in this case that was not done. Now, this point didn't escape the Supreme Court, or it certainly didn't escape Her Honour Justice Glazebrook, who, as Your Honour might realise, was the primary author of the Cullinane judgment. And at the top of page 149, we provide an extract, and Her Honour said it was submitted by Mr Davison QC that the record of case was faulty because there were a number of conclusory statements, effectively submissions in the record, especially related to the alleged existence of a conspiracy. He submits that the appellants are entitled to copies of the documents or other materials underlying those conclusory statements. Her Honour says, I agree that there are some conclusory statements in the record of the case, but the evidence relied on, or at least a selection of that evidence is set out. Either that evidence supports the conclusions and inferences the United States wants to draw to support the existence of a prima facie case, or it does not. As already indicated, it is for the requesting state to decide what information to put forward in support of those inferences, and it takes the risk that if insufficient material is provided, the extradition judge will not be satisfied that a prima facie case exists. Now, in our submission, sir, Her Honour is confirming that conclusory statements of themselves aren't going to be sufficient. You've got to look behind those statements and see whether there's evidence to support the conclusions that are set out. In fact, though, the problem of conclusory statements is, as Your Honour will well know, is recognised in the law of evidence, especially in relation to ex parte applications for warrants. And a common example of a conclusory statement is evidence that a police informant is reliable. And so in Kahika, the Court of Appeal had a look at that particular issue and quoted from a Supreme Court of Canada case called Greff, where the court said the leading case in the area of assessing confidential information is Queen and Debott, a decision of the Ontario Court of Appeal. The Court of Appeal held that the information supplied by a reliable informant may provide the reasonable and probable grounds to believe in order to justify the granting of a search warrant. That reasoning is applied by the court when the issue is reasonable and probable grounds to justify a warrantless search, as in the case at bar. The test for assessing the information is as follows. Quotes, I am of the view that such a mere conclusory statement made by an informer to a police officer would not constitute grounds for conducting a warrantless search. Highly relevant are whether the informer's tip contains sufficient detail to ensure it's based on more than mere rumour or gossip, whether the informer discloses his or her source or means of knowledge, and whether there are any indicia of his or her reliability, such as the supplying of reliable information in the past, etc. And then going back to the main body of the decision of the Ontario Court of Appeal was confirmed by the Supreme Court. The question raised by the appeal is a factual issue, depending largely on the inferences one is able or prepared to draw from what is said and not said in the affidavit. In the view of the majority of the court, this doesn't go far enough. And then the underlined words, in terms of Greff, the informant's assertions are certainly an example of a conclusory statement, although not a mere conclusory statement in the sense that there is nothing else. In terms of the indicia which Justice Lama thought important, there is no material enabling the issuing officer to gauge whether the tip was based on more than rumour or gossip, nor is it stated whether the informant disclosed his or her source or means of knowledge. And then further down, the underlined word, stripped to its essentials, and putting aside the statement that the suspect is associated with a gang with known involvement in criminal activity, all that remains is a conclusory statement by an informant. Whether that was based on rumour or gossip or other hearsay, or on the other hand was solidly grounded on some reliable information or observation, we simply do not know. All we have for sure is that in an unspecified way, the informant has given satisfactory information in the past. So, although that's the subject matter of that case is very far removed from the present, the problem is not. The problem of conclusory assertions is something that comes up in that context and indeed in other contexts as well. So we refer to another judgment of our Supreme Court in a case called Harrison at the bottom of the page and over to 151, where in the underlined words the court said it is simply not sufficient for a police officer to assert a belief that an informant is reliable when that clearly would have necessitated further inquiries that had not been carried out, despite counsel having previously raised the issue. And those two cases, Kahika and Harrison, were cited by the Court of Appeal in the further case of Chan, 2002. Mr. Shaw submitted that the veracity and reliability of a police informant whose information is invoked in support of an application for a search warrant goes to the heart of the reasonable belief of the applicant. A bare assertion of belief as to reliability without any supporting primary facts would not satisfy the reasonable belief requirement. And in our submission, so that reference to supporting primary facts is very important and significant. And then some cases are referred to in support of the proposition that evidence of informant reliability requires more than just a conclusory statement to that effect. And then at the foot of the page, under the underlined words, the inadequacy of conclusory statements and the necessity for sufficient primary material to enable the judicial officer to be satisfied of the necessary statutory matters has been referred to in other decisions of this court. Now, over to our 533. As can be seen from those extracts, the problem with conclusory assertions is that they prevent the court from evaluating the underlying facts upon which the conclusory assertion is supposedly based. That defeats the whole purpose of judicial evaluation because it draws a veil over the primary facts and replaces those facts with an assertion that can't be examined or challenged other than by cross-examination. And when, as in the present case, cross-examination is unavailable, a conclusory statement subverts the statutory objective, which is to make the judge the assessor of facts, not the witness. We then refer to Auckland and Tower Insurance, which was a Justice Asher judgment, so that's why we've referred to Your Honour. And this is a particularly helpful analysis under our Evidence Act legislation. Statements of opinion are prima facie inadmissible. However, Section 25 of the Evidence Act sets out the basis upon which they can be admitted. And this is familiar territory. The underlined words, bald statements such as these cannot be weighed or evaluated by a fact finder. For that to be done, the fact finder must know at least an outline of the facts relied on by the expert and his or her reasoning. No attempt is made in this brief to present either.
You could probably add that the underlying facts need to be known to the parties so that they have an opportunity to make meaningful submissions about their adequacy.
That's right, Your Honour.
Everybody has to be able to scrutinise it.
Yes, otherwise it's put beyond the reach
of everyone.
Of everyone. And so His Honour says, as I've indicated, I will get no help from such bald conclusory statements. The only way I could get assistance if Mr. MacDonald was called would be to ask him some questions myself as to his reasoning, but I would then be exposing the defendant to prejudice, and new material may well come forward of which it had no notice. And His Honour was saying that because counsel, who was Mr. Galbraith, had said he wasn't going to cross-examine, he was simply relying upon the conclusory assertions point. I must say that in evaluating the help I might get from the evidence, I'm also conscious of Mr. MacDonald's or the plaintiff's failure or inability to provide reasons despite my indication and the provision of an opportunity to do so. This in itself puts a further question mark over the value of his evidence. The issue can be considered in terms of Section 8 of the Evidence Act, that is in assessing its probative value against its unfairly prejudicial effect. Well, we accept that that doesn't apply under Section 25. Standing alone, however, they could be seen as having an unfairly prejudicial effect in that they are of a conclusory nature adverse to the defendant's position. And so, as Your Honour has just reflected back, putting a factual issue beyond the reach of the decision maker and beyond the reach of the parties cannot ever have been the purpose of Section 25.
I mean, Tower's a little bit different because it's dealing with an expert, and under the code, the expert has got to unpack the reasons for opinion so that that can properly be scrutinised.
Yes.
So it's a little different. But
it is, of course, a different context, and of course Your Honour's entitled to take those comments. But what we say is here, the situation is even vastly more important than the situation that His Honour was considering there.
Sure.
You've got a civil case with an expert giving evidence. Here, you've got a situation where a prima facie case it is being considered in circumstances where the decision is going to affect the very life of the person concerned. here, sir, we have ventured into United States law because we managed to find a case called Ashcroft and Iqbal, where in relation to a pleadings point, the US Supreme Court discussed the question of naked assertions devoid of further factual enhancement. To survive, this is the second main paragraph, to survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The plausibility standard is not akin to a probability requirement, but it asks for more than a sheer possibility that a defendant has acted unlawfully. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. So that's, there are some quotes from an earlier case called Twombly. And then, so the court then goes on to say, in this case, two working principles underlie our decision in Twombly. First, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. And then this, threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Although for the purposes of a motion to dismiss we must take all of the factual allegations in the complaint as true, we are not bound to accept as true a legal conclusion couched as a factual allegation. And then it goes on, and the final passage underlined. In keeping with these principles, a court considering a motion to dismiss can choose to begin by identifying pleadings that, because they are no more than conclusions, are not entitled to the assumption of truth. Yeah. While legal conclusions can provide the framework of a complaint, they must be supported by factual allegations. When there are well-pleaded factual allegations, a court should assume their veracity and then determine whether they can plausibly give rise to an entitlement to relief.
I mean, that's a pleadings issue, though, isn't it?
It's a pleadings issue,
yeah.
But the court is grappling with exactly the same situation that comes up in a variety of different circumstances.
You can't plead conclusions, you've got to plead facts.
That's right. And we say, under Section 25, you can't recite conclusions,
yeah.
and you've got to recite the facts. So it's the...
well, it's a step further, it's summarising evidence.
Yes, Section 25 has its own...
A pleading is talking about facts. What we're talking about here is a summary of evidence.
But evidence...
To establish asserted facts or pleaded facts.
Well, evidence is always fact.
Yes. Well, I mean, you can plead facts, but what we're talking about under Section 25 is what is the summary of the evidence to establish the asserted facts.
Yes.
So,
yes.
So this case is a little off point, isn't it?
Well, the only reason that we're referring to it is we are saying that the question of the issue about conclusory assertions comes up in a wide variety of situations.
Conclusory assertions are no good in pleadings, and they're certainly no good as evidence.
That's right. And we don't want to take that case any further than that. That's just another illustration.
I think you've well and truly cracked that nut.
Right. So, but there is one other point that comes out of Iqbal,
right.
Which we say is a significant point for Your Honour. The additional, and this is at 537, the additional insight provided by Iqbal is that a legal conclusion may be couched as a factual allegation. In other words, there can be sleight of hand in this area, and that the judge should be aware of the deceptive technique of dressing up a legal conclusion to make it look as though it is merely an allegation of fact. And in our submission, sir, that seems to be a fair principle to apply in our jurisdiction as well in the present context. So we then go on to refer to the various references in the record of case to copyright works and infringing copies, and we say that they are in reality conclusory assertions of law, and they cannot be conclusory assertions about New Zealand law. They must be conclusory assertions about US law. They have to be, because these are, the ROC purports to be a summary of evidence of witnesses in the United States who are going to give evidence at trial. So that puts it even further beyond the reach of the assessor, because foreign law, as Your Honour will recall from cases like Dimmock, foreign law is treated in our jurisdiction as a question of fact and to be established by expert evidence. So if the basis for the foreign law assertions is not disclosed to the adjudicator, to the judge, then that whole issue is put beyond the reach of assessment. So we say under both New Zealand law and US law, copyright is a legal right that pertains if and only if certain factual preconditions are shown to exist. We know that much about US copyright law. To assert that an object is a copyright work or an infringing copy is to assert a legal conclusion. To do so without even attempting to provide a summary of the facts on which those assertions are based contravenes the requirement in section 25 to provide a summary of evidence. A legal conclusion is not evidence. So we next come on to the colour-coded ROC. I want to check that, sir, and I'll hand it up after the lunch break.
Well, you take the break whenever you want, because we're going to have a shorter session this afternoon anyway.
Well, that would be a very convenient time, sir, because I can check that document and make sure we've got the right. I know what I'm talking about when I hand it up.
Well, that's good. What time do you want to reconvene?
Well, if we break now, sir, and reconvene at 2 o'clock,
2 o'clock,
and finish at 3:15 or somewhere about there, that would be helpful.
All right, we'll adjourn until 2 o'clock.
Koe hiki te koke te koa, ono naratai, court is adjourned.
Thank you.
High Court Cinemas, how are you?
Mr. Illingworth.
Your Honour, we have a present for you. Some
Oh, I
more
see.
paper.
Right.
Um,
Okay.
so what Your Honour has,
This is what was handed into the district court.
it's exactly what was handed into the district court, Your Honour. So you'll see that one of them is the colour-coded document, and the other one has highlights only in respect of conclusory statements as to copyright. So if you open that one first, Your Honour, you'll
Yes.
see throughout the material there are references to copyright and copyright infringing activity, copyright infringement. So it actually gives you a visual picture of how many times those assertions are made, and we say they are unsubstantiated assertions. The other one is the fully colour-coded version. You'll see that on the second, or the page just behind the title page, the intitulling, there's a key,
Yes.
ABC, with orange, yellow and green and what they mean.
Yes, it's reproduced in your submissions as well.
So we don't need to take Your Honour through that.
No.
But what it does do is to show you that those tools were made available to the district court. And even though there could be argument about the parameters and the particular coding, there was at least a very important issue to be decided, and His Honour doesn't engage on that topic. So we submit that His Honour hasn't differentiated between the different categories within the record of case. So there's a bit of an analysis of that on page 156, which Your Honour can read. Then at 157, the bullet point in the middle of the page is put as an alternative submission to the outright rejection of the ROC, that if the ROC is to remain, that all extraneous material should have been excised and disregarded. Excised only in the sense that His Honour could have said, for example, well, I've seen this colour-coded version and I'm only relying on the green portions or in some other way, but that wasn't done. There was no response to our submission on the point. We then go on to a new topic on page 158, which is that there was no preservation of evidence for the trial, and of course that's an issue under section 25(3)(a).
The material you've just given me doesn't include SROC 8, presumably.
No. I was going to explain that. So there's a separate record of case under the tabs. I think it's tabs 1 to 4. There is a separate record of case for each extradition defendant. Then you'll see supplementary ROCs after that going up to supplementary ROC 7, and supplementary ROC 8 is not included.
No.
Oh, and we've only put in 2 in the colour-coded version, one for Mr. Ortmann and one for Mr. Kolk. So we haven't done a colour-coding exercise for Mr. Dotcom and Mr. Batato. But the position there should be very, very similar. Now, Your Honour has probably heard enough about Ferris to last a very long time indeed, but at the top of page 159 there is an extract which we haven't quoted earlier, which actually is very important both for the point that we've just been looking at in relation to assertions and also in relation to preservation of evidence, and so it can be brought into play for both of those purposes. So top of 159, the court said similarly, where evidence is certified as available by a requesting state, that certification results in a presumption of availability for trial. However, cases might arise where a person sought could cogently challenge the presumption of availability of evidence for trial. For example, where a person sought can show that a requesting state relies on evidence of a witness who prior to the extradition hearing retracted his or her statement. The availability of that evidence for trial may be brought into doubt. Another example is where a state makes only a bare assertion that evidence exists without providing any description whatsoever of its content or form. In such a case, the availability of the evidence may be in doubt. Furthermore, an extradition judge does not make a prediction about the future state of the evidence. He or she makes a common sense determination about whether the evidence exists and is available for trial at the time of the extradition hearing based on the evidence itself. Any circumstantial guarantees of availability, such as certification, and any evidence tended to dispute the presumption of availability for trial. So we go down to the bottom of the page and refer to Mr. Rothkin's evidence that the mega upload servers had been taken offline. They'd been removed from a remote controlled environment, that the situation could cause data loss. And at 561, Professor Sellis confirms that electronic media is likely to deteriorate when stored in unsuitable environments, and he's not cross-examined on that point. So the evidence is that there's a real risk that mega upload files are currently deteriorating and may not be available for trial. If the plaintiffs were to be extradited, the US certification that evidence has been preserved for trial cannot then be entirely correct. Mr. Rothkin confirmed on cross-examination that the plaintiffs had been provided with an index of the files on the mega upload servers, including file names and MD5 hash numbers, but not the underlying file content, and that was also confirmed by Mr. Ortmann. And the point is made that a file can be named anything that the user chooses. Mr. Dotcom explained the point well in his evidence. He said, so if you have someone with a file called Cinderella.movie, you know that could be a Cinderella wedding, that could be a Cinderella birthday party. You can't tell what the title means without having access to the actual file. We never got any access to any of the files. And that's confirmed by Mr. Ortmann. Does the file name always correspond with the file? No. So simply from a file name, is it possible to determine whether the file complies with copyright or not? Not with the required certainty. And I also want to mention that the file in itself is not necessarily infringing. It is the context in which it is uploaded and in particular downloaded that determines the infringing status. And then Professor Sellis confirms that the MD5 hash doesn't give any information about a file's content, and that's explained in the quoted evidence, and in particular where he says these are encrypted values, so that there's nothing that's very interpretable by a human eye. These encrypted values could be reduced to hexadecimal values, so you could have a binary representation of what is there, but again that would take some time for a human eye to read and accurately reinterpret. That would be done programmatically. And so he explains what that means. He then later gives evidence that the file name doesn't necessarily give an accurate indication of its contents. Over the top of page 162, the file names are part of metadata, and of course they are open to human intervention. So in our submission, Your Honour, it's only by examining the files themselves that the content can be identified. So that's one aspect of the primary facts, if you like, that would have to be considered in when assessing the question of copyright. Now, if we move down to the bottom of page 163,
What we're talking about here is not preserving all of the evidence that might be relevant for the trial, presumably, but rather preserving the evidence that's summarised in the record of case.
yes, but that may be that's an unresolved issue as a matter of interpretation of Section 25.
So you don't accept that?
No, I don't accept that, sir. It's equally open to the broader view that the evidence is to be preserved.
All of the evidence?
Yes, all of the evidence.
All potential evidence for the trial must be
No,
preserved?
all of the evidence that the prosecuting authority has in its possession or power.
Right. So the Section 25, you say, is not directed just to the evidence that's summarised for the purposes of the record of case?
Well, it's a very difficult point, sir, because where do you draw the line? The certificate is required. It's an essential part of the Section 25 process, and if there's vagueness about what that certificate applies to, that brings the whole concept of the record of the case into question. If Section 25 is interpreted so as to mean all of the evidence that the prosecuting authority has at its disposal, then there is no grey area. Whereas if you say all of the evidence that is summarised, how does the certifier know whether that certificate, whether the certificate he or she is required to sign is correct or not? It just it blurs the boundaries. That's
well,
what I'm
does
saying.
it really? I mean, if the certificate says, here is the summary of the evidence that we contend is sufficient to satisfy all the elements of these particular counts for trial purposes. That's a summary of it. So you can look at the sufficiency of that to see whether, if that conduct had incurred in New Zealand, the pathway offences would be made out. But what the certificate is additionally doing is saying all of that evidence that we've summarised to justify this has been preserved. So it's not a question of evidence that we used to have but don't any longer have, and therefore wouldn't be able to offer. But it doesn't have to go beyond whatever the requesting state chooses to put forward as a sufficient foundation to support a prosecution.
So we accept that Section 25 is open to that interpretation, but the difficulty arises in relation to documents and items that are incorporated by reference in the summary.
Yes. So does it matter in this case to your argument? Or do you say all of the evidence that is summarised in the ROC?
We say it does matter in this case because if
the interpretation point matters.
Yes, because if every computer file that is referred to in the ROC has to be preserved as evidence, then that is totally different from saying that the witness statements that are the subject of the certification have to be preserved.
What if the requesting state had obtained some evidence in the course of its investigation which, if it had remained available, would have been important and would have been adduced at the trial but not critical? Do you say that a failure to preserve or maintain that evidence would be fatal to the certificate?
I don't think that proposition would stand up to scrutiny.
I don't think so either.
But at the same time, that is almost certainly what the Supreme Court is referring to under the duty of candour. So that as long as if, for example, the prosecuting authority said in the certificate, this is all the evidence that we have, and it's what we've preserved for trial, but at the same time disclosed that it had previously had some evidence which has since been destroyed or something of that sort, then the combination of the certificate plus the compliance with the duty of candour would be a fulfilment of what the requesting state was required to do.
But why would the requested state be concerned with that? Isn't the concern more directed to whether there is a sufficient evidence of an extradition offence?
Yes.
And that it remains available. So,
but the
so
question,
the extradition court works on the assumption that the evidence that's referred to has not only been obtained, it has been preserved and is able at that moment still to be presented in court at a trial.
and that has to be right in terms of the underlying rationale of Section 25.
Yes.
Because the requested state does not want to be put in, should not be in a position where a case, evidence that's used to make out a prima facie case isn't in fact available.
It's no longer available.
No,
Hasn't been preserved. Yes,
that would be an injustice, because the person who faces
Yes.
trial then finds out that evidence is no longer available.
But you say that the requirement goes beyond that.
Also, the edges, the case at the margins is the problem, because where do we draw the line between a simple case where a victim says, I was raped by the defendant. The witness statement is recorded, the evidence is preserved, it's available for trial, very simple. But here we have incorporation by reference into the summary of a whole lot of computer files and other material that may or may not be preserved for trial. Now, and you've seen from the document that we just handed up to you, dozens and dozens and dozens of references to allegedly infringing material. Now, what has to be preserved? Is it simply the witness statement, or is it the material that supports that witness statement? That's where the difficulty arises. And I suppose my simplistic answer is that if all of the evidence in the possession of the requesting state is, if they certify that it's preserved, then there is no room for debate about the other materials. That may be too simple an answer, but it does seem wrong for a situation to develop where exhibits are referred to in the summary. If those exhibits haven't been preserved,
Yes.
is that a proper subject of certification?
Well, if the exhibit is referred to in the summary as evidence and it's then presumably the certificate covers it.
Yeah. Well, that's the key proposition from our point of view, because we say there are a lot of computer files that that are referred to in the summary or in the record of case, which may or may not be summarised evidence, which have been allowed to deteriorate, and which can't be certified to be available for trial. And that's the evidence given by the witnesses, unchallenged.
It doesn't use the words available. It's preserved for use, isn't it? It's the same
Preserved
thing,
for
but-
use, yeah.
Okay. Well, preserved for use. Does that not permit of some level of degradation? Maybe. I'm not sure how.
So the certificate and the affidavit and the duty of candour are three prongs, if you like, of this concept of responsibility of the requesting state. Now, if there is a limitation to be placed on the certificate, then the requesting state must, in response to the duty of candour, be required to disclose it. And the consequence of that, in terms of the record of case procedure, would be for the extradition judge to determine.
Right.
We can't lose sight of the fact, sir, that this whole case involves a company that is said to be operating a cloud storage facility or an electronic computer facility, which is at the centre of the case. And if that facility is being allowed to degrade to the point where the information can't be accessed, that surely comes within the focus of the preservation issue. So it's not an immaterial point in this case. It's an essential point. We just have a moment, sir. Yes, sir, the point that's being drawn to my attention is that in the extradition proceeding, we now know from the Supreme Court case that full-scale disclosure is not available in the same sense as we would expect in a trial situation. So, for example, in a trial situation in New Zealand under the Criminal Disclosure Act, you'd get full disclosure.
Yeah.
And we can assume that similar responsibilities would lie on the requesting state at trial in the overseas country. So an aspect of preservation for use in the person's trial, as is stated in subsection 3 of section 25, is that preserves the ability to provide full disclosure at the appropriate time, which is prior to trial.
But those are requirements in the requesting state jurisdiction, aren't they?
They are, but the point is that the certificate about the affidavit about preservation fulfills a function in relation to the later trial, if any, as well as satisfying the requirements of the extradition court to make sure that justice is being done.
Yes, although it's a question of what part of the evidence. Is it all of the evidence, or is it the evidence that's relied on to justify the extradition that's sought?
Well, even adopting the narrower point, one does have to look at the contents of the record of case,
yes, of course,
to see what is incorporated by reference.
That's right. Anything that's in there, you say, that is relied on as evidence, the certificate covers it.
Yeah. So if Your Honour goes to the bottom of our 163, you'll see that we pick up exactly that issue. As an example, we refer to paragraph 24 of the record of case, and we've set that out at the bottom of the page and going over into the next page. That refers to multiple databases, and then there are 3 paragraphs that refer to a preliminary analysis which is said to show certain things from those databases.
Yes.
Now, the problem is that while it says that the databases have been copied, it doesn't say anything about files being copied. And I'm not saying that there isn't anything elsewhere in the record of case, but at least those databases are something that needs to be preserved. But what about the files? So it's just an illustration of where the boundaries can be blurred, and what does the certificate have to refer to, and just the difficulty of drawing the line. In fact, the record of case refers repeatedly to computer files and asserts that they are infringing copies. The evidence incorporates those files by reference, and the files are a crucial part of the case. None of the charges can succeed without those files being identified and classified. It seems clear that the files themselves have not been preserved, and we say that that's a fatal difficulty under Section 25, because multiple computer files are referred to and alleged to be infringing. Now, that doesn't mean that the United States couldn't have satisfied a prima facie case test by adducing evidence outside Section 25. Section 25 is a shortcut procedure, and it's non-exclusive. It says so specifically. But and so it's not. We're not asking the court to put up a barrier to extradition by saying Section 25 can't operate in this situation. It's not a barrier. The old fashioned approach to an extradition procedure remains available, but the US has chosen to avail itself of a shortcut in circumstances where that shortcut doesn't seem to be available because of the nature of the case. And no extraneous evidence on these points has been given. Extraneous in the sense of outside the record of case procedure. So the point we make in our paragraph 582 is that Section 25(3)(a) must be there to give the extradition court some comfort that there will be a fair trial in the requesting state. The requesting state is allowed to summarise evidence on the basis that the court is satisfied that the underlying evidence it has summarised exists and has been preserved for trial. And at the very least, that must include exhibits that are incorporated by reference. Now, we then give at the top of 166, we refer to the question of validity of certification. And we raise a challenge to the certification in this case. Firstly, on the ground that much of the record of case is not evidence. Secondly, the absence of any work-by-work analysis of copyright or breach of copyright, both as to ownership and infringement. And thirdly, the absence of relevant documents. And then fourthly, the evidence of Professor Lessig in which defects in the indictment and the charges are outlined. And Your Honour, I'm not going to go through the detail of that except to cover for the moment the question of copyright, which starts on 168. Mr. Mansfield is going to provide Your Honour with as I understand it, a very detailed analysis of copyright issues in the context of the present case, and I'm not wanting to trespass on that area. I will leave that to him. So what we say here is merely by way of introduction on that point. But what we do say, Your Honour, is that, picking it up at 597, there is no common law of copyright. That's simply an elementary proposition in copyright law. In every country in the world where copyright is recognised and enforced, including New Zealand and the United States, copyright is entirely a creature of statute. Each country has its own set of rules, and there's no requirement for international consistency. And I just add to that, so the concept of territoriality. Copyright is by necessity territorial, and every textbook on copyright law will make that point. But each count in the superseding indictment ultimately depends on allegations of breach of copyright. We've already seen that racketeering is an umbrella offence, that the umbrella covers breach of copyright, money laundering, and wire fraud. Money laundering is a derivative offence. That can't be established unless the copyright issue is established, and similarly the fraud by wire offences all depend ultimately on the copyright issue. And so against that background, we say it is indeed a very surprising feature of the present case that no evidence was presented to the district court of any basic facts from which the court could make legitimate findings about the ownership of copyright, copyright infringement in respect of any single work or object which is the subject of any of the charges. In other words, a work-by-work analysis. And we say, Your Honour, that on any view, a work-by-work analysis is essential in this area of the law, whether we're dealing with New Zealand law or US law or some other law. Now, we illustrate the point by reference to a judgment of our Supreme Court, admittedly in a civil case, but you would think that proving civil liability is less onerous than proving criminal liability, and there's no reason why the basic ingredients should be starkly different. So the Supreme Court, I think Justice Tipping at the helm in this instance, says this statement got the plaintiff's case off to an unfortunate start by claiming copyright in the packaging rather than in the artistic work underlying the packaging. As will become apparent for later purposes, this failure to distinguish the commercial product from the artistic work underlying it seems to have caused quite unnecessary difficulty and complexity, particularly in the High Court, but also to some extent in the Court of Appeal. Counsel for Henkel appears ultimately to have accepted in the Court of Appeal that his client's claim to ownership of the copyright in an artistic work had to focus on the underlying drawing rather than on the commercial product manufactured from that drawing. This is, of course, entirely correct. The reason is that the packaging is no more than a lawful copy of the original graphic work. As a copy, it has no such originality as would justify its being regarded in itself as an independent copyright work. So here we see the basic germ of an idea that the particular work that is said to be the original copyright work is the starting point for the analysis. And the court then goes on to address a related issue. Counsel for Hinkle then advanced the proposition that Hinkle owned the copyright in quotes, the blue image design. This was an even more difficult proposition than the proposition that Hinkle owned the copyright in the blue image packaging. At least the packaging was a physical object. The design as a design had no physical manifestation. Copyright does not protect ideas as such, only the physical expression of those ideas. So here we see that we're in an esoteric area, an area in which a technical understanding of the situation is extremely important, and broad brush allegations don't work. So again, this passage illustrates the importance of identifying the specific work that is said to attract copyright protection. It is impossible even to begin to determine whether a particular work is capable of attracting legal protection without knowing precise information about the work and its provenance. A generalized, non-specific approach is fatally inconsistent with the whole concept of copyright protection. We then have the Court of Appeal focusing on the pleadings issue, where, interestingly, both Justice Baragwanath and Justice William Young were prepared to accept that the appellate argument fell within the scope of the pleaded claim, but the late Justice Chambers dissented on that issue, and the Supreme Court upheld Justice Chambers and said Justice Chambers specifically and correctly directed himself that it is of the essence of a claim for breach of copyright that the plaintiff identify the work which is said to have been wrongfully copied. And then further down, the present point is that Justice Chambers correctly identified that the copyright works in issue were associated with Super Bonder and QuickTight and not with Super Attack. Now, in other words, the specific work which was said to be the entitled to copyright protection had to be correctly identified. The court went on to uphold that dissenting judgment, and there was the court concluded that Hinkle's failure to plead the copyright work on which it was ultimately seeking to rely must result in its inability to rely on that work. Now, that's all a matter of civil pleading and need not detain us, but it follows that at least under New Zealand law, it's absolutely essential for a party who asserts a breach of copyright to identify with clarity and precision the work in respect of which it is said that copyright inures and has been infringed. We make the submission that even though Hinkle is civil, the standard of proof is of course higher in a criminal case, and even the lower prima facie case standard must be at least equivalent to the civil standard. But the Hinkle court then goes on further to clarify aspects of the copyright law in New Zealand, and it did so as a means of being helpful in terms of clarifying the law rather than in terms of what was necessary to resolve the case. Basically, the court's giving guidance on the issue for future reference. So the court says the law of copyright in New Zealand is governed by the Copyright Act. It has close parallels with the relevant parts of the UK Act. It's implicit in the earlier part of these, as is implicit in the earlier part of these reasons, the plaintiff must first clearly and accurately identify the copyright work or works in respect of which it is claiming infringement. And then further on, at the bottom of the page, once the plaintiff has identified the work for which it's claiming copyright, it is next necessary for the plaintiff to establish that the work is an original work. The concept of originality is not defined in the Act, and common law principles apply. The Act does, however, prescribe when a work is not original. That will be so if it is, or to the extent that it is, a copy or infringement of another work. The Act thus gives some guide to the common law concept of originality, which must be carefully distinguished from novelty. There need be nothing novel in a work to qualify it for copyright protection. to be original for copyright purposes, the work must originate from its author and must be the product of more than minimal skill and labour. Now, it'll be obvious, sir, that what we're talking about here is the New Zealand position, not the United States position. But when questions of foreign law are an issue, it's not uncommon for the court to conclude that the foreign law will be similar to the New Zealand law. That's a point that could be taken. But more importantly, what it demonstrates is that if we're going to be talking about an overseas regime, how important is it to have expert opinion on these points? How can points of this kind be established by an FBI agent saying this is a work of copyright? Someone who hasn't qualified in any way to give an expert opinion. And then it goes on. The Supreme Court then goes on to consider proof of ownership in the following way. Subject to the exceptions described in Section 21 of the Act, the author of a work is the first owner of any copyright in that work. Conventional exceptions relate to employers and those who commission the making of qualifying works. They are, generally speaking, the first owner of the copyright in the work. We know that the statute constitutes copyright as a property right. And being a property right, it is a legal construct. It's a legal construct within our jurisdiction, but how our law is recognised and how copyright in a New Zealand work is recognised overseas will be a matter for the domestic jurisdiction of the other country. So this is an area that is full of legal steps and legal constructs such as we have here. Who is the first owner of the copyright, and has that copyright been passed on to someone else? Has the copyright been sold, or are there licensing arrangements? And if the copyright has been conferred in an overseas jurisdiction, such as the United States, what does that law say about the ability to make a copy of the item in question for your own use? Are you allowed to buy a DVD which contains a movie, upload it to a cloud storage facilities so that you can play it on your TV or your computer later? There's a whole question of fair use or personal use that comes into play at that point in time. We don't know what that law is because we haven't had any expert opinion from the US on the point, and we haven't been able to access that ourselves, which is the July stay issue. So we say at 614, it is usually essential for a copyright claimant to prove who was the author of the work, whether the work was created in an employment context or on commission, and the position can't be any different in a criminal prosecution in New Zealand. Specific identification is also important in relation to the need to assess the degree of originality in the work, or the degree of originality in the work. So again in Henkel, the Supreme Court refers to this issue, and the court says, as we observed earlier, it may be relevant for infringement purposes to determine how much skill and labour went into the making of the copyright work. This point can have particular relevance in arrangement cases. The skill and labour which has given rise to the arrangement is what gives the work its originality, and if that skill and labour is not great, another arrangement of the same unoriginal underlying features may not have to depart greatly from the copyright arrangement in order to avoid infringement. If the level of originality in the copyright arrangement is low, the amount of originality required to qualify another arrangement of the same elements as original is also likely to be low. Substantial reproduction of those aspects of the work in which the originality lies must be shown to establish infringement. This is consistent with the purpose of the law of copyright, which is to recognise and protect the skill and labour of the author of the copyright work. Now, you'll see later in the case, Your Honour, certainly in our reply submissions, that we refer to an American case which is relied upon by counsel for the United States. It's a case called Hot File. And in that case, you will see an American expert judge displaying huge and admirable forensic skill in navigating through the US law of copyright in a civil context. Now, the United States has relied upon that case. We've responded by addressing it. But you'll see the degree of sophistication, the steps that are required to analyse the US position. It is a truly formidable forensic exercise. We don't know whether the judge got it right or wrong, but we can say it's a very impressive, or it appears very impressive to an outsider. In a way that is very similar to what the Supreme Court are saying in Henkel, there are numerous steps that need to be considered, numerous technical points. The US law is extremely significant in terms of that analysis, and it is by no means a simple process. So our court, the Hot File case is a case about infringement in a civil environment. This present case, Your Honour, and Hot File deals with a cloud storage company being pursued in a civil context. One thing that Mr. Prabhu has not disclosed in his affidavit is that there hasn't been a prosecution in relation to a cloud storage company in the United States in relation to the conduct of clients of the cloud storage company in the criminal, under the criminal law. It has happened in civil, but not criminal. This is proposed to be a test case on infringement with criminal law in a criminal law environment. So if we come back to our page 173, in Henkel, the Supreme Court goes on to consider the issue of infringement and says the ultimate issue in a breach of copyright case concerns derivation, not similarity, albeit the degree of similarity between the copyright work and the allegedly infringing work has evidentiary significance. Proof of copying will seldom be direct. In most cases, the court will rely on inference. The closer the similarity between the two works, the stronger the inference is likely to be that one was copied from the other. So this implicitly is talking about proof of the original and comparison with the alleged copy. Now, we don't see that in the record of case at all. And then further on, it is not necessary for the plaintiff to show that the defendant copied the whole of the copyright work or that copying was exact. It's enough if the plaintiff demonstrates that the defendant copied a substantial part of this copyright work. This can sometimes be a difficult matter of evaluation and is usually the most difficult question which arises in copyright cases. What amounts to a substantial part in an artistic work case depends more on qualitative visual impression rather than on quantitative analysis. As it has helpfully been put, what must have been copied is the essence of the copyright work. This is a subject upon which in borderline cases minds can reasonably differ, and so on. So the court is saying, well, you've got to compare the original work with the alleged copy. You've got to be satisfied that the original work is the subject of copyright, and you've got to be satisfied that the copy contains the essence of the original work. Now, how can those issues be given a meaningful judicial assessment when the basis for that is a series of conclusory assertions made by an unqualified person, and without the benefit of the local rules being established by evidence? Now, we say at the top of 174, the points mentioned in relation to Henkel are by no means a complete description of the technical requirements of copyright law in New Zealand. Attached as Appendix B is an outline of the various issues that would confront a prosecutor seeking to establish a criminal breach of copyright in the New Zealand context under the Copyright Act. And so there's a whole schedule of material there that Your Honour may or may not want to look at, but using want in a very broad sense. But the reason for outlining the law of New Zealand in relation to breach of copyright is that, well, there are two possibilities. First of all, Section 24.2d can be interpreted, we need to modify the wording of our Section 20, can be interpreted as requiring the court to be satisfied that the evidence produced or given at the hearing would, according to the law of New Zealand, justify the person's trial if the conduct constituting the offence had occurred within the jurisdiction of New Zealand. Also, the United States relies specifically on Section 131 of the Copyright Act as a deemed treaty offence in this proceeding. But just going back to the phrase, according to the law of New Zealand, Your Honour will recall that the Cullinan Court expressed the view that those words in 24.2d related to procedural issues only, and in our understanding that point hasn't been conclusively determined, and it's an open point so far as Your Honour is concerned. And so the point, what we've said there depends on whether the relevant aspect of Cullinan is held to have been correctly decided, or whether Your Honour decides that it is binding upon you. That is, whether Section 24.2d is merely procedural. But the alternative has to be that US copyright law applies. But no evidence, no expert evidence has been given except for the basic statute. Expert evidence would then be needed, and Your Honour will be sick of hearing it, but we've been denied the opportunity to get our own version of that evidence. Now, this point is an absolutely crucial one in terms not just of the rights and wrongs of the district court case in relation to matters of law. It's crucial to the outcome. It's crucial to the question of whether the plaintiffs in this case are entitled to walk free. Because if Your Honour holds that proof of copyright and infringement of copyright were necessary ingredients of the offences, and if that proof has not been given in accordance with the procedures set out in Section 25, then they're entitled to be discharged, having been held here for 4.5 years under conditions. Now, so this point goes to the very root of their right to be free or otherwise. And in our submission, sir, the case has not been established. A prima facie case has not been established. So all of the other legal points really are, in a sense, less consequential than this one, because this goes to the very root of the question as to whether a prima facie case has been made out. And so what we say, Your Honour, is that if the situation is judged according to the law of New Zealand, even though Henkel is a civil case, it demonstrates very clearly the minimum standard in terms of proof that has to apply equally, if not more so, in the criminal law context. So if the law of New Zealand applies, the case has not been established. If the law of the United States applies, then even more so, the requesting state has a major problem because it's failed to give expert evidence on a crucial issue. Now, we then go on, Your Honour, to provide a brief analysis of the record of case in terms of copyright at paragraph 625. There appear to be something like 520 allegedly copyright works in issue, but the record of case and supplements contain no proof whatever that those works were protected by the law of copyright at the time of the alleged offending. The most that the record of case does is to assert that the item in question is a copyright work, either explicitly or impliedly. And given the essentiality of breach of copyright to all of the charges, and I include the conspiracy charges, because my friend is going to say, well, some of these charges are conspiracy charges, so you don't have to prove the substantive offence. But I'll come back to that later. We are submitting, sir, that proof of copyright and breach of copyright is the foundation of this case, and that foundation has not been laid.
Yeah. Well, it's conspiracy to aid and abet in some cases, isn't it?
Well,
Conspiracy to assist others to commit the breach.
I'll duck that question for the moment, if I may, sir. And I have to think about that over the weekend. I haven't understood the United States to be relying upon an amalgam of conspiracy and aiding and abetting. Normally, those two things are viewed separately. So,
well, conspiracy to do an unlawful act. It would be an unlawful act, wouldn't it, to aid or abet a breach of copyright?
I'm not sure. I'm not sure that any of the charges are framed in that way, sir.
Well, I might be just raising a complete red herring. I'm not sure.
Well, I'm grateful for you raising it, sir, because it gives us the opportunity to think about it. But
well, if you look at count. Count 6, for example. Aiding and abetting criminal copyright infringement.
Yes. There's an and in between, sir.
Yes.
So it's criminal copyright infringement by electronic means and aiding and abetting criminal copyright infringement.
So are there two offences there? Or is it just that some of the defendants are aiders and abettors and others are
Yes.
principals?
Yeah.
Is that how you
That's my
interpret-
understanding of it.
And is that common ground?
I don't know if it's common ground, but that's certainly not a conspiracy charge.
No, that wasn't a good choice.
I don't think any of the charges after count 4 are framed as conspiracy charges. I might be wrong about that. Am I wrong about that?
Right, agreed.
I'm correct about that.
Right,
Good
okay.
that I'm correct about something for a change.
We found common ground.
Yeah, at last. Count 1 is conspiracy to commit racketeering.
Yes.
Count 2 is conspiracy to commit copyright infringement. And then count 3, I've lost count 3.
Money laundering.
Yes. And that is a conspiracy charge.
Yes.
So there doesn't seem to be anything that is framed as a
Conspiracy to aid or abet.
to aid and abet
Right.
others to commit offences. But what about conspiracy to commit copyright infringement? To take the most direct example,
Yeah, count 2.
count 2. What we say about that, Your Honour, and we've dealt with it somewhere in our submissions, but I might as well explain it now, seeing as we're on the point. What we say is that there is no direct evidence of any unlawful agreement. So looking at just using the ordinary New Zealand concepts, probably not dissimilar from what Mr. Prabhu has outlined in his affidavit on the issue, a conspiracy is an agreement to do an unlawful act, as Your Honour just said. Now, under our statutory law, Section 310 of the Crimes Act, to be an unlawful conspiracy under our present law, it has to be a conspiracy to commit an offence. And Section 310 says that. Under the old Section 257 that was repealed, I can't remember when, under the old Section 257, a conspiracy to defraud was an offence. But the defrauding didn't need to be an offence in itself. So there are issues about that. But just leaving that distinction aside for the moment, in circumstances where there is no direct evidence of an agreement, where there's an agreement to do something wrong, to put it in a neutral way, whether it be an offence or some form of fraud or something of that kind, where there's no direct evidence, the case will commonly be proved by reference to the so-called overt acts of the conspiracy. So, to take a common example, a packet arrives at the post office, in the post office box. There's evidence that that package has been sent by someone and picked up by someone, and that they must have done that by agreement. And if the contents of the packet are some form of illicit drugs, then an inference can be drawn from the overt conduct to the effect that the agreement between the sender and the recipient must have been an unlawful agreement. So that there's an inference drawn from circumstantial evidence, which is a form of reverse engineering, if you like, reconstructing what the agreement must have been, even though there's no direct evidence of it. Now, that reverse engineering process depends upon the contents of the package. if the package is salt, contains salt, then it's obviously difficult to infer an unlawful agreement. If the package contains cocaine, it might be very easy to draw an adverse inference and say that there's a circumstantial case. In a situation where the alleged conspiracy is a conspiracy supposedly to commit copyright infringement, and there's no evidence of the parties entering into an unlawful agreement, no direct evidence, then the case depends on circumstantial evidence and inferences to be drawn therefrom. And if there's no proof of unlawfulness at the overt act stage, then the necessary inference can't be drawn. So in a conspiracy case, except where there's direct evidence of an unlawful agreement, it will pretty much always be essential to prove the unlawfulness of the overt acts, or at the very least the wrongfulness of those overt acts under the old system that we had under Section 257. Now, all of that is simply a way of saying that this is a case about copyright enforcement. And in the absence of evidence of unlawfulness and knowledge of unlawfulness, it is impossible to see how the United States case can work. So we say that this copyright issue underpins the whole case, including the conspiracy charges. Now, this is all without going into the question of what does the US law permit in terms of fair use, in terms of copying a file that's owned to be stored on a person's computer or computer system. For example, now that cloud storage is a very common phenomenon, instead of copying something onto my hard drive, I might simply copy it onto a virtual hard drive. The virtual hard drive is in fact a cloud storage company like Dropbox or OneDrive or SkyDrive or all of the different drives which pretend, if you like, to be the same as my hard drive on my computer, but in fact are external and are accessed via the internet. Now, unless you know who owns the copyright, what licensing arrangements are in place, has the person bought the DVD or the we probably don't even need a DVD nowadays. Has it been downloaded via Netflix or one of these organisations that have licensing rights? In the case of songs, there are providers that allow you to download copies of music, presumably in accordance with licensing arrangements. Those copies, like iTunes, Apple iTunes, can be stored on your computer. They can also be stored on your virtual hard drive. How do we know whether the work that's actually stored within the servers of the cloud storage company, how do we know that they are unlawful or illegitimate files? So that's the starting point. well, it's actually not the starting point. The starting point is who created that work, what's the law of copyright that applies, where did the work originate from, the law of which country applies. There are a whole host of issues that need to be addressed. What are the fair use laws? And is a cloud storage company that provides the opportunity for people to store information liable simply because the user does something wrongful, which is the dual use technology
Yes.
issue. So that's a convenient place for me to leave the submission, sir, and I can come back to it on Monday.
All right. A tough week for you, Mr. Illingworth. But now, are there any issues that any council needs to raise before we break for the week? No? All right, thank you. We'll adjourn until 10 o'clock on Monday.
Koe hiki te kotia tuko.